Let us begin. It is my pleasure to welcome you all to today's event, For Whom the Bell Tolls, Climate Rights and Litigation. My name is Aljosha Petak. I'm an environmental lawyer here at PITS, the Slovenian Center for the Protection of Human Rights and the Environment, and I will be moderating today's event. Our primary mission here at PITS is to assist civil society in all of its forms and associations in effectively participating in environmental decision-making, and also to effectively participate and enforce a just and sustainable future for all of us. This event is a part of the project Discussions and Actions on Climate and Environment, which we are implementing as one of the partners in the network Justice and Environment. The project is financed by the European Union. The timing of today's event, which is dedicated firstly to the connection between human rights and climate change, and secondly, the possibilities of climate litigation, is in a way perfect. The recent decision of the European Court of Human Rights found Switzerland in breach of the Article 8 of the European Convention on Human Rights, the right to respect for private and family life, because of its failure to comply with its duties. The state had not acted in time and in an appropriate way to devise, develop, and implement legislation and measures to mitigate the effects of climate change. It is an important legal victory and a solid addition to all the existing legal developments in the climate change and human rights fields, and a good overture for today's event. A little bit of a technical background. There will be 7 presentations today and 2 short 10-minute breaks at approximately 11:30 and 1 p.m. With the exception of first presentation, which is pre-recorded, you will be able to ask the presenter questions through the Q&A window, which you can find at the bottom of your Zoom screen. You're able to upvote questions from others, those of course that you would like to see answered the most, and I am very happy to report that downvoting is not possible. The first speaker today will be David R. Boyd, who was appointed as the UN Special Rapporteur on Human Rights and the Environment for a 3-year term in 2018. He is also an Associate Professor of Law, Policy and Sustainability at the University of British Columbia. He has advised many governments on environmental, constitutional, and human rights policy, and co-chaired Vancouver's effort to become the world's greenest city by 2020. He is a member of the World Commission on Environmental Law, an expert advisor for the UN's Harmony with Nature initiative, and a member of Environmental Law Alliance Worldwide. Mr. Boyd is also the author of 9 books and over 100 reports and articles on environmental law and policy, human rights, and constitutional law. One of his most recent books is The Rights to Nature. While visiting several countries and preparing one of his reports, he also visited Slovenia and gave a voice to local communities which fought for the right to a healthy living environment, which is in Slovenia a constitutional right. Mr. Boyd pre-recorded a 10-minute contribution, which we will listen to now. Due to technical difficulties Mr. Boyd had on his country mission, we have only audio in which he gives us some general outlines of the current legal and practical situation from the perspective of his function. So here is the video.
Hello, I'm Dr. David Boyd, the United Nations Special Rapporteur on the right to a clean, healthy, and sustainable environment. I'm sorry I'm not joining you live, but I'm on a country mission in the Maldives, an archipelago nation in the Indian Ocean that is really on the front lines of the global climate emergency. The Maldives is facing an existential threat because of sea level rise, floods, extreme weather events, coastal erosion, salinization of their drinking water, ocean heating, ocean acidification, and other aspects of the climate crisis. And this is having dramatic impacts on people's human rights. The right to food, the right to health, the right to water and sanitation, and of course, the right to a clean, healthy, and sustainable environment. The rights of the child, cultural rights. There is no question that the climate crisis is also a human rights crisis. On my travels as Special Rapporteur, I have witnessed the extraordinary impacts of the climate crisis upon the lives of people living in already difficult circumstances. These are populations who are vulnerable or marginalized. I think of people in rural Botswana suffering from intense heat, increasing food scarcity, increasing water scarcity, increasing human-wildlife conflict. I think of people in Chile who have been in the midst of a drought for more than a decade and are having difficulties getting access to safe and sufficient water. People I met in Portugal who are scarred by their experiences surviving wildfires of unprecedented intensity several years ago. And of course, I traveled to northern Norway where I met with indigenous Sami people whose reindeer are dying. Reindeer are the heart of their economy, the heart of their culture, and changing weather patterns during the winter are leading to the starvation of the Sami's reindeer. So as I said, the climate crisis is a human rights crisis. And we have witnessed over the past 30 years the failure of international environmental law to address this crisis. Since 1992, when nations agreed to the UN Framework Convention on Climate Change, global greenhouse gas emissions have risen by more than 65%. This is truly a striking failure. And so the world's leading scientists, the Intergovernmental Panel on Climate Change, are calling for systemic and transformative changes to all sectors of society. That is a colossal challenge because we have vested interests, powerful businesses, wealthy elites who are making immense profits from the current system and are very resistant to changing it. But if we look back through recent centuries of human experience, we see that systemic and transformative changes are possible. And in many of those situations, human rights have been a critical catalyst. Think of the abolition of slavery, where abolitionists argued for equality and freedom. Think of the women's rights movement. Think of the campaign to end apartheid in South Africa based on human rights. Think of the progress made by persons with disabilities, indigenous peoples, and others in recent years. Human rights are not a silver bullet or a magic solution, but they do have a track record of catalyzing systemic and transformative changes. And that's where we have reason for hope, because in 2021 and 2022 at the Human Rights Council and the General Assembly, the United Nations has recognized for the first time the human right to live in a clean, healthy, and sustainable environment. Of course, this is not a new human right. This human right dates back decades in countries like Slovenia and Portugal. And as of today, 161 nations recognize this right in law, either in their constitutions, their legislation, or in regional human rights treaties. So we know from decades of experience that the right to a healthy environment includes a bundle of procedural elements and a bundle of substantive elements. The procedural elements include access to information, public participation in decision-making, access to justice with effective remedies, freedom of speech, freedom of assembly, and freedom of association. The substantive elements of the right to a healthy environment include clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments where people can live, work, study, and play, healthy ecosystems and biodiversity, and of particular importance given today's topic, a safe, livable climate. This right to a healthy environment is also interpreted according to guiding principles drawn from international human rights law and international environmental law. These include prevention, precaution, the polluter pays principle, non-discrimination, and non-regression. And it's encouraging to see that the right to a healthy environment is now making an impact around the world in the context of the climate crisis. We have courts from Hawaii and Montana in the United States confirming that the right to a healthy environment includes the right to a safe, livable climate. Indeed, this was also one of the outcomes of a recent decision of the Inter-American Court of Human Rights The case was focused on air pollution, but also made some comments about the content of the right to a healthy environment, indicating that it includes a safe climate. And so courts are clarifying the obligations of states when it comes to their climate and environmental obligations. And this is one of the key advantages of human rights-based approaches, is that it clarifies the obligations and responsibilities of states and businesses. Human rights-based approaches also place a focus on those people who are being left behind, people in situations of vulnerability and marginalization. And finally, a human rights-based approach also provides people with institutions and mechanisms that they can use to hold states accountable. So I just want to read very briefly one paragraph from the recent decision of the Inter-American Court. It's dealing with one substantive element of the right to a healthy environment, which is the right to breathe clean air. But I think it's interesting because the Inter-American Court is in the process of preparing an advisory opinion on human rights and the climate emergency. So as I'm reading this paragraph, just think of how the Inter-American Court will deal with the right to a safe, livable climate in much the same way. The court wrote in this case, which is called Inhabitants of La Oroya versus Peru. The Inter-American Court wrote, quote, "People enjoy the right to breathe air whose pollution levels do not constitute a significant risk to the enjoyment of their human rights, particularly the rights to a healthy environment, health, personal integrity, and life. People enjoy the right to breathe clean air as a substantive component of the right to a healthy environment. Therefore, the state is obliged to A, establish laws, regulations, and policies that regulate air quality standards that do not constitute risks to health. B, monitor air quality and inform the population of possible health risks. C, carry out action plans to control air quality that include the identification of the main sources of air pollution and implement measures to enforce air quality standards. States must design their regulations, plans, and air quality control measures in accordance with the best science available." So imagine that in the context of the right to a safe climate. Courts are going to make it clear that states, particularly wealthy, historically and current high-emitting states, such as the United States, Canada, Australia, Japan, European states, those wealthy states have legal obligations to rapidly reduce their greenhouse gas emissions. And that means three things: phasing out fossil fuels as rapidly as possible, ending deforestation, both domestically and in supply chains, as rapidly as possible, and transforming the current industrial agriculture system, moving away from meat-heavy diets to diets that are predominantly plant-based. Those are obligations, not options. And in order to ensure a sustainable and livable future for people in countries like Botswana, Chile, and where I am today, the Maldives, these actions need to be taken with unprecedented urgency. I hope you have a terrific conversation today, and really love the fact that this conference is named after one of my favorite Ernest Hemingway novels, For Whom the Bell Tolls. Thank you all for the work that you are doing, and I look forward to continued cooperation and collaboration. Thank you very much.
We already thanked Mr. David Boyd for his contribution. For Whom the Bell Tolls was also used as a title of a Metallica song, which I'm sure some of you are familiar with, and might be a little bit more of an appropriate tune for the current state of climate these days. But let us move on. The first presenter joining us live today is Professor Stephen Humphreys. Professor Humphreys is a professor of international law at the London School of Economics and Political Science. He's a commissioner on the EUCN World Commission on Environmental Law. He was also a lead author for the Intergovernmental Panel on Climate Change's special report on global warming of 1.5. an academic advisor to the International Bar Association's Task Force on Climate Justice and Human Rights. He was formerly research director in the International Council on Human Rights Policy in Geneva, and before that, senior officer at the Open Society Institute's Justice Initiative in New York and Budapest. He has conducted policy work on climate change and in human rights in a variety of fora. His research interests include international legal and critical theory, rule of law, law and development, climate change, the laws of war, and transnational legal process. He holds a PhD from Cambridge and a master's degree in law from SOAS. His publications include Theater of the Rule of Law and the edited volume, Human Rights and Climate Change. His presentation today will address some human rights dimension of global climate policy. We are very happy to have you here with us, and you're willing to join us today, Professor, and the floor is yours.
Hi, can you hear me?
Yes, everything is fine.
Okay, good. Well, thank you very much for inviting me, Ayosha, and Luca, of course, whom I don't see, but I assume is here somewhere. Yeah, so it's nice to follow up after David. I don't know David very well. We've met a couple of times, and we probably see these things from slightly different angles, though of course his work is superb. What I thought I would do, so as Ayosha mentioned in his introduction, I put out a book on this in 2010 on human rights and climate change, with the uninspiring title "Human Rights and Climate Change," and that book derived from. Let me put up a PowerPoint here, actually, so that. I'm not seeing that I can pull up a PowerPoint. Will this work? I have no idea what I'm going to see now. Should I be able to share my screen?
Yes, you should be able to.
Okay, I'm not seeing that I can. Oh, wait, I see. It's asking. Forgive me, this is apparently wanting, I mean, I've done this a million times. I don't know why it's looking for it now. Wanting me to go through various. I'm going to have to quit and reopen.
All right.
Is that okay?
Yeah.
Okay.
All right, is everything working now? Great. Just unmute yourself, please.
You would think after 3 years of this stuff, it would all come naturally, but I don't think it ever will. So what I was saying was the book I put out in 2010 derived from a project that I undertook when I was working in Geneva with a group called the International Council on Human Rights Policy in 2007 and 8. And what we did was an initial deep dive, if you like, into the questions concerning human rights and climate change, which resulted in this report that you can see here on the slide, with the equally inspired title "Climate Change and Human Rights: A Rough Guide." Now, the reason I go back to this is that was quite a long time ago. The report came out in 2008. What we did in Geneva in this think tank, which was not a part of the UN, but was established by a group of people who were involved in setting up the Office of the High Commissioner of Human Rights initially, and which had the job of forward thinking on human rights questions to inform UN and other international processes. We gathered together academics and practitioners and people who've been thinking about this from around the world to Geneva and had a round table and then produced a report on that basis. And what's fascinating to me now, and it was fascinating at the time, was this was 2007. I had personally been working on climate change since 1996. I'd been working on human rights since about 2000. And there was almost no work available at that time looking at both of these issues side by side, despite the fact that I think we all agree in the room, the links between them are very obvious and clear. At the time, there was a case that had been brought to the Inter-American Court, the Inuit case, which the American court deemed inadmissible, but they had a hearing about it in any case. Very interesting case, which looked entirely at climate impacts in the Arctic regions. And there was a movement taking place in the Maldives. I see David is in the Maldives right now. The Maldives have long been one of the primary actors in forwarding this set of issues. Their then President Mohammed Nasheed organized a meeting there, which produced something called the Mali Declaration and gave us some of our initial language that you actually find in the Paris Agreement on the set of issues. So there wasn't much there, and what was there was relatively scant. So what we tried to do was to open the field up to a bit more academic and policy context. And the reason I'm going back to it now is partly because in lots of ways I'm not really working so much in this field anymore, but also because I think it's a good time to sort of take stock, global stock taking, a la Article 14 of Paris, to take stock and see where things have moved on in the last 15 odd years and how well we're doing. And of course, we heard a relatively upbeat assessment just now. I arrived slightly late, but that's how it sounded to me. I'm probably less upbeat myself, in part because, of course, in the last 15 years, we have failed entirely to bring down greenhouse gas emissions. And that's not just the last 15 years, that's the last 34 years since Rio in 1992. It's an extraordinary failure, absolutely extraordinary failure, which leaves us in a really quite serious situation when it comes to human rights. When we started looking at this, part of our thinking was, it was already 20 years after Rio, part of our thinking was, we can add to this process perhaps by bringing in the importance of human rights. Here's an element of this that people aren't paying attention to. If we start to think and talk about this concern in climate change, perhaps that will help to prod policy in the right direction. And as we'll see, perhaps there have been maybe some successes. But I think it's very hard for me in the time that's passed since to call this a real success. In any case, what we tried to do is to look at it from 4 different angles. So we're all aware of the climate change impacts on human rights. And we have a list of human rights that people habitually refer to: life, health, food, shelter, water, self-determination often arise, and others. But aside from the human rights effects of impacts, we also thought it's worth looking at the human rights impact of climate change policy. So we have a series of policies that are beginning to take shape around this time to do with mitigation, to do with adaptation. We are, at this time that I'm writing, 10 years after the Kyoto Agreement, but almost 10 years before the Paris one. We suggested that we might find ourselves talking about climate change in terms of emergency, and we're lawyers, so we're working with lawyers. And of course, from a human rights perspective, the invocation of emergency is generally not a great thing. Where we find ourselves today is that, in fact, we increasingly speak about a climate change emergency, and that wasn't the case in 2007. And there, I suppose, the relevant human rights, again, David Boyd listed them, are rights to information, rights to participation, process rights when it comes to those policies, at a minimum. But there's also the impacts of policies, and I'll say maybe a bit more about that in a moment. Then our third angle was in terms of text. So you have this series of international law texts dealing with climate change on the one hand and human rights on the other. And we were wondering about the extent to which they converge or are coherent or diverge in various different ways. And here the context is an international law field, which I'm sure you're all aware is characterized by fragmentation. There's a series of bodies of law dealing with different topics that often seem to exist in isolation from one another without any clear sense as to how they're supposed to work together. And I think this is exactly what we see happening when we look to recent cases coming through the human rights courts dealing with climate change. They look to both bodies of law and see how they can put them together. Another excellent example, perhaps, is the question of climate refugees and migrants, and the long-standing question as to whether or not they fit within the 1951 Geneva Refugee Convention. And the very significant pushback from the bodies tasked with looking after that convention, the High Commission on Refugees and the IOM, making it very clear that they're not going to accept even the term climate refugees. This is, I think, one of the quite profound problems we meet. And so that takes us into the general context. We wanted to step back a bit further again. You have this set of texts doing different kinds of work, and you have a context in which that takes place. Fragmentation is part of that context. Another part, perhaps, is the way the climate change international law apparatus itself is rooted in a particular international law moment from the 1960s, 70s, which we often call the New International Economic Order. So the UNFCCC is full of terms that think about the relation between North and South and the post-colonial context and readdressing those justice issues arising from decolonization. That's a part of the package. On the other side of the room, so to speak, you have the fact that climate law arises at the same time as contemporary trade law. So the WTO was created in 1995, just after the climate change agreements. And you find this convergence between the texts. The UNFCCC's Article 3.5 refers directly to the WTO GATT agreement. So the assumption of liberal trade, the assumption that any efforts by governments to impede trade is a form of protectionism, is clearly part of the context in which climate change runs amok in the 1990s at the same time as a legal framework in principle comes into place. Okay. Ayosha, you're going to have to tell me if I'm going over here, but I'll keep going until you tell me to stop. Our next element to this puzzle at the time was to try and identify human rights within a broader context of what we started calling and came to be called by other people at the same time, climate justice. And that can mean many different things. So one way of trying to break it down into meaningful bits is to think about it in terms of 4 different or 5 different sorts of justice claims that are made in the climate context. And when we do this, and you'll see as I do this, what we were really focused on at this time, and to me, it still seems to be the main focus relevant to human rights that is often neglected when we then turn to human rights instruments, is the fact that northern countries, wealthier countries, former colonial powers are historically responsible for the climate problem. They've contributed most to it. The wealthier a country is, the larger its carbon footprint is. So to this day, prosperity aligns with responsibility for causing it, if you like. While at the same time, and almost by coincidence, the countries that are most deeply and profoundly affected by climate change are mainly in the global south, are mainly relatively poorer, and are mainly former colonies. So you have a set of historical justice issues that are sort of mapped onto a set of contemporary justice issues, that responsibility among the North and the vulnerability in the South. So the first justice claim is one about climate impacts. It affects countries' behavior, predominantly in wealthy countries, increasingly, of course, at this point in China and India are major contributors as well, affecting people in other parts of the world. And that gives rise to a disbalance, an extraterritorial problem, a problem of harm, a problem of making amends, a problem of compensation. The second major justice claim had to do with the removal of fossil fuels in the future as a motor of growth. So if poorer countries were to contribute to addressing the climate problem, they would effectively find themselves unable to address their own developmental problems. And this was, of course, the point of view of the Global South right from the beginning of climate negotiations, and is why it's positioned within the New International Economic Order. This is, of course, a set of human rights concerns, because the way in which we address the rights to food, health, shelter, and water, and so on, are through development. We haven't really found other ways of doing that. So if we're going to ask for countries to stop using fossil fuels, we create this problem of a potential development freeze or of locked inequality. The third problem is a procedural justice problem, which is, well, who gets to decide how we sort these things out? And the problem there tends to be one of there being no forum within which a global public, so to speak, can come to agreement as to how best to do these things. And then the fourth justice claim, which I think is often in the background but quite important, is a question of ownership rights. And that is the fact that those countries and companies that have been using the global carbon dump, that have been emitting carbon over the decades and centuries, have, you might say, acquired a right to usage, and they don't want to give it up. And of course, that plays a very big role in the background of all of our discussions about climate change, the fact that we're asking people who are using something to stop using it and they don't want to stop. And they have law on their side in the main. So a problem of acquired rights. And to this, you might add a fifth concern that you would characterize as a justice concern, and that is a criminal law concern. Why is it that the amount of harm caused by climate change doesn't fall into our international criminal framework? Once again, we see that there are moves to try and make that happen, but it's very slow progress, and it's, in my view, quite unlikely that we'll see much progress in that area anytime soon. Now, curiously, for those the four that exist, justice claims I just outlined here, we find them addressed to some extent within the climate regime. So the problem of making amends is addressed by a global mitigation policy. Emitters must stop, cease and desist from emitting. And to some extent, a global adaptation policy, which expects at some level transfers from the high emitting countries to the low emitting countries to make up for or compensate for the loss that they are experiencing and the harms that they've experienced due to climate change. Now, it's never called compensation, but that's the sort of frame in which it takes place. To the second problem, developmental freeze problem, the UNFCCC treats it with what's called technology transfer. The idea we would make technologies available to address the developmental drawbacks and thereby promote, in principle, the capacity for progress in typical areas of human rights. For procedural justice, of course, we have the UNFCCC process itself, the caravan that appears every year of 10 or 13,000 people. And for the formal justice problem, the problem of entitlements or ownership or acquired rights, we have the recognition through the various, in particular, market schemes, the flexible mechanisms of Kyoto and Article 6 of Paris, perhaps, which puts in place the notion that those who have been using this stuff to date have a certain right to it, maybe reducing or capped over time, but in principle, we start from that premise, a recognition of that existing rights. And over time, I think what we've seen is that these various different elements of the climate regime have expanded or contracted at different rates. Technology transfer is almost invisible today, whereas the ETS, various ETS regimes are quite prominent, at least in the way we think and talk about climate policy. Okay, what I was going to do, I maybe as well to stop there, was quickly go through a set of recommendations we made at the time to assess the degree to which these now seem to have been met or not in the intervening decade and a half. Will I say something quickly about that, or should I?
Yes, you're well within your time, so you have actually 10 more minutes if you want.
Okay. Oh, good. Okay. Good. Okay. So we outlined at the end of this report here, which you can find in SSRN because the actual organization is no longer with us, has an appendix, a couple of appendixes, one of which picks out from the IPCC reports and various other sources where we locate human rights concerns arising in climate change scenarios and predictions, and a second of which outlines areas for future human rights engagement. And at the time, there was almost nothing going on. So among them, and they're under four headers here: advocacy, mitigation, adaptation, and litigation. When it came to advocacy, we were suggesting, we weren't alone in this. There were various, SEAL in particular, the Center for International Environmental Law, was incredibly active and remains incredibly active in this area, doing a lot of this kind of work too. We met with them at the time. First was to insert human rights sensitivity into a post-Kyoto regime. So we were negotiating Paris. We were actually negotiating Copenhagen at the time, 2008, 2009. Copenhagen came to nothing, so it becomes Paris. And the move was to bring human rights directly into the climate change regime. What we were essentially doing here was dealing with two silos, two different epistemic communities, right, who didn't really speak each other's language and trying to get them to converse and dialogue. And there was a big push to refer to human rights in the Paris Agreement, which is undertaken at the highest level. I was working at this time with Mary Robinson. She was involved with the International Council on Human Rights Policy. She was very well placed to bring these things into these international negotiations. There were concrete proposals to have human rights wording in the Paris Agreement. They were rejected ultimately, and what we get, as you may be aware, is a paragraph in the preamble, which is pretty vague and hard to follow, on the importance of considering human rights dimensions of climate change. So some success, maybe not as much as we might like. Certainly nothing concrete or enforceable, as we like to say. The next was this flip side of that, was bringing climate change concerns into the foreground of existing human rights advocacy. Around about 2008, 2009, I visited Human Rights Watch and their headquarters in New York, and Amnesty International in London, and various other organizations, to raise with them the idea that maybe they should be thinking about climate change. And they were all interested, but they were very, very cautious. It didn't look like a traditional human rights problem to them at the time, for the obvious reason that we didn't really have any victims, and human rights organizations need victims. We're not in the habit of forward thinking about problems that may occur in future with abstract, if you like, victims. So they were slow, and as you know, got there about 5 years later. And now, of course, it's top of the agenda for these guys. And I think that's fantastic. That's a great success. Not my success, but a general success. That said, I still often find myself wondering, well, what can they do with this problem, right? The main problem, just to reiterate, when it comes to human rights is, I think, the problem of extraterritoriality. We have victims in one part of the world and the middle is in another. And there's a certain matchup, but it's not a very good matchup. So that's something I'll come back to later on. So we hope that you might then get input from human rights organizations into things like the construction of a mitigation regime. If you look to the work of a group like SEAL or even Human Rights Watch at the moment, they're very, very active in this area, actually. There's endless lobbying going on at the COPs and in Bonn and so forth to try and bring human rights concerns into REDD+ programs, into the Article 6 negotiations, for example, as they continue, with a certain amount of success. I'm not sure success is the word, but anyway, it's there and it's present and people are aware of it. Ditto when it comes to adaptation and technology transfer, and I'll say more about those maybe in a minute. And then the question of the Sustainable Development Goals, or the right to development. As I'm sure many of you are aware in this room, the right to development has a checkered history as an element of the human rights regime. It was always associated with the new international economic order and seen as a very political tool to address power differentials between North and South, if you like. And appears in the UNFCCC in this very peculiar form of states have a right to promote sustainable development. That said, with the replacement of the MDGs by the Sustainable Development Goals in 2015, we wind up having at least a language, as international lawyers will tell you, a very loose and in lots of ways unsatisfactory language and baggagey, but nevertheless a language which seems to link together a set of human rights concerns with a set of developmental concerns with a set of climate concerns, and that's all to the good. In the IPCC process, for example, the SDGs figure very strongly. I'm sure some of you are aware, there's constant reference back to the SDGs. That's kind of become mainstream, if you like, through international policymaking. And then the other area of advocacy was this idea that maybe we should be thinking about climate change as a criminal offense rather than a kind of a tort. And that takes us, I suppose, into ideas such as ecocide. Wait, what happened there? I think oh yeah, sorry, yes. So a next area was litigation. And here we foresaw a number of spaces in which we might expect increasingly over time litigation to happen. Now, at that time, I think we were somewhat concerned that litigation was most likely after the fact. The problem with law is, as I say, you need concrete victims. So the time now with climate change, as you're aware, is that we get ourselves to a situation in which we're sort of not dependent for the next 20 or 30 years. It's very difficult to look backwards and fix things that have just happened, because if you like, the gun is already loaded for the next few decades by the time something has happened. And so from that point of view, litigation is a blunt instrument here. And one would expect policy, planning to be a much more effective way of dealing with climate change. But there are, of course, all sorts of other problems too. In the case of the very obvious example of state responsibility, there was already form in the form of Tuvalu having at one point mooted the idea that it might take the United States to the International Court of Justice on the basis that Tuvalu was sinking and the US was a major emitter. And the way the story goes, getting a telephone call from the Department of State to say, if you pursue this, we'll cut funding and make sure that you're not able to get any further funding, and stepping back quickly. Now, whether things have changed or not, from that perspective, you're aware that, of course, Vanuatu is now doing something similar to that. They're not suing, so to speak, the US, so to speak. They're seeking instead an advisory opinion. And the path of the advisory opinion has been mooted repeatedly over the last 20 years. Some of you will be aware various states have lifted it and then dropped it again. Bangladesh was interested for a long time. Pakistan was. And finally, Vanuatu are going ahead with it. I'd be very interested to hear what people think in the room. I think it's admirable in many respects, but also very dangerous, because it's very easy in this context to get a result that you're not really looking for, and quite difficult, I think, to get the result that you hope for. And if you don't get what you want, then it's a bit hard to know what to do next. But there's also, of course, as you're aware, a process before the Inter-American Court, which David referred to a moment ago, brought by Colombia and Chile, asking something similar. Extensive question, looking at the various elements of human rights and climate change law and other areas of international law that seem relevant. So that's something. Okay, worth evaluating perhaps. The next is, of course, the notion that you might want to target government regulators or public officials for harms that are actually happening or that are perhaps imminent due to their failure to address the problem. So the failure to regulate, or maybe you're looking for injunctive relief, perhaps saying, well, these particular processes should stop now because they're causing harm or will cause harm. And over the years, we've increasingly seen this particular tool being raised. The best known example, of course, in the human rights domain is probably Urgenda, the Dutch case, which is seen in many respects as being groundbreaking. I tend to be a little bit of a skeptic on these things. It was good, of course, to win a case like Urgenda and to set the precedent that a court can direct a government to alter its policy in climate change. The actual alteration, of course, was relatively minimal, and it was after the fact, because the court process took so long that by the time we had the final Supreme Court ruling in the Netherlands, the actual deadline was a couple of days later. So the state wasn't really in a position to do anything about policy, and the court was aware of this. So the processual elements, the political elements, the legal elements tend not to match very well in this space. Also, of course, Urgenda raised the problem of the rights of people outside of the Netherlands in the first instance ruling, and got nowhere with that. And I think that's a problem. Similarly, in the Neubauer case in front of the German Federal Constitutional Court, the victims from Bangladesh and Pakistan Nepal also applied in that case and were given, in principle, standing by the court. And then the claims were essentially set aside. Although, from a certain point of view, they're far more pressing in Bangladesh than they are in Germany. So again, the court was willing to step in and said the government needs to do a bit more, but it wasn't willing to step in and say Germany has obligations towards people in Pakistan or Bangladesh and Nepal. And we find exactly the same thing then happening when it comes to the European Court of Human Rights. The Duarte Agostinho case is notable for the, I think, utterly unnecessary, frankly, absolute dismissal of any acknowledgement of extraterritorial obligations in the context of climate change with regard to persons living outside the Council of Europe, drawing on previous case law, which had nothing to do with climate change in the main, which was to do with war situations, and which, of course, was very firmly rejecting the notion of extraterritorial responsibility. Now, the weird thing is, it seems to me, and maybe people have views about this in the room, that there were all sorts of opportunities before the court to find another way to think about this problem of the extraterritorial effects of greenhouse gas emissions, and the court simply refused to take it on. They did even worse, in my opinion, at least. With the Swiss case that actually went through, the Klima Senioren case, where they literally refused to find anything wrong with Swiss policy. This is despite the fact that UNEP and the IPCC have made it clear that current NDCs aren't adequate to the Paris targets. Apparently, the court didn't feel there was any way they could bring human rights to bear on the substantive elements of climate policy. They stuck entirely to the procedural elements. And in the Swiss case, those were pretty unusual elements in the first place, because the law had been rejected by referendum. So maybe other people have other views. It's been generally hailed as a good thing. I'm very uncertain. I think if a court can't even say to the Swiss government, this is an inadequate policy, then we're not going to find human rights courts helping here. Other people might think differently. Next was, of course, private actors, and corporate actors are responsible in all sorts of ways for climate change. You might make them the principal protagonist. And again, we have the extraterritorial issue that carbon emissions produced in territory X have impacts in territory Y, and that problem has been made most explicit in the case that's been in front of the German courts for a very long time now, involving the utility company RWE and a Peruvian farmer by the name of Luya. I'm not quite sure what's happened with that case. Maybe somebody knows more than I do. It's been waiting for quite a while now, and I understand they want to take account of the various other kinds of litigation happening in the world. Duarte Agostinho will not be encouraging from this point of view, but it's a civil claim in principle. And were anything to happen, of course, it would be seismic. But that's also anyway. So other reasons one might want to target private or corporate actors is for direct human rights harms. So the Philippines case, the Human Rights Commission in the Philippines brought a case quite like Luya, but the other way around, where they were trying to charge carbon majors, or seeking a way to find responsibility amongst the carbon majors, 90 different companies around the world in fossil fuels and cement, for the typhoon that hit Philippines in 2011. And it was a wonderful process with which I had a slight bit of involvement in the LSE. Not though leading to anything, enforceable in the international domain.
Sorry, Professor, if you could please conclude in a minute.
I got there. I got through my
Okay.
Okay, good.
Thank you.
I can. You can see the rest of these examples haven't really haven't got very far. Some investment activity when it comes to companies, and investor activism, you might say. And with the question of trade sanctions, what we find instead is a move towards the CBAM in the EU context to address emissions abroad. Okay, I won't go through these two, just to point out that there were also questions about adaptation policy and mitigation policy. In none of which I think have we made great progress when it comes to bringing human rights to bear on these situations. The adaptation is very far behind. Technology transfer hasn't happened at all. And the last thing, simply to say that we didn't, in that report, talk about the right to a clean and healthy environment, which I think maybe we want to talk about in the room. It may add something. The question of future generations was left out deliberately, and I'm now on record as standing against future generations as a useful or viable way into the climate problem. And again, I'm happy to talk more about that. And the question of loss and damage wasn't on the agenda. It was just coming up, actually, around about that time, 2009, which, of course, is worrying that we're now at a point where what we're concerned about is irreversible harms instead of harms that we should have and could have obviated before they took place. So I'll stop there. Thank you, Arisha.
Thank you very much for your presentation. Very interesting thoughts. And we have already very interesting questions, and I'm just going to dig right into them. Ina Bertak is asking if, in your personal opinion, is there a need for a new global protocol on climate change, one that will target the human rights problem due to climate change? This might be the first question.
I think that's a very good question, and it's a very difficult question because what we have a need for and what we're likely to get tend to be two very different things, unfortunately. So, I mean, the short answer is yes, we have a need for that, and we have a need for a lot more besides that. What slightly concerns me, and I feel somewhat similar about the right to a clean and healthy environment, or ecocide for that matter, is once you enter into an international law process to try and acquire these things, or give them some sort of legs, you're immediately into sort of a political horse trading domain in which what you finally get never looks like what you wanted in the first place, and then important states don't sign up to it, and then the institutions that are supposed to enforce it don't have teeth. The whole thing takes 10 to 20 years, and what you get at the end is never really what you wanted. Or like an environmental international court, it poses a similar problem, I think. And the problem with that is what I think is what I was referring to as context in my first slide. The concern is that in the background, enough important actors don't really want this to happen to make sure it doesn't happen. So in a way, you can try all sorts of routes and hope for the best, but with the change we need is a little bit more radical and needs to kind of come from somewhere else. So yes, but also with some concern.
Next question would be a little bit of a thought-provoking question, or not. Are human rights compatible with free market ideology? It's a question from Matthias Bockel.
Yeah, it's a very good question. Obviously, I can't answer that question. Insofar as I can, I would direct you to my other book, The Theatre of the Rule of Law, which deals with promotion of the rule of law around the world, and which I would argue really asks whether international development policy, at least in the form it took in the 90s and aughties, if that's the right word, really wants to make the world a safer place for capitalism, ultimately. Whether that's free market ideology, I'm not entirely sure. But that's come under all sorts of attack and critique and questions since the financial crisis of 2008. Nothing profound has changed yet. My sense is that the climate problem is really the motor of change. It's making a difference in so many areas that the fundamentals there are beginning to be questioned, just as a matter of practice. What that means for human rights, though, I'm concerned, I must say. Not sure that's a helpful answer. It's a big question.
It's a tough question. It's a tough one. Ina de Meer, thanks you for your presentation and asks about the Vanuatu advisory opinion proceeding before the ICJ. What are your views regarding the possible impact of this verdict on climate litigation before other courts or even climate policies or states?
Okay, so this is the kind of question to which I personally have to be careful I don't sound too glass half empty-ish about it, because I'm not even sure the glass is a third full, not to mention a half full. But one thing that is happening clearly is that the courts are understanding their limitations. They're beginning to get to grips with the language. As I said at the outset, we identified, I think, what you call a path dependency problem. We had in 2005 or 6 a climate change epistemic community, if you like, very large, actually. The IPCC is an enormous institution. Tens of thousands of scientists have been through the IPCC process. Not very many social scientists, not very many lawyers, but that's changing slightly. Whereas human rights people with whom I've done a lot of work, they just simply speak a very different kind of language. They have a different set of methodologies, a different understanding of what knowledge is. And the task, in a way, it seems to me, was to try and bring those two registers together to create a dialogue. And that is happening. So insofar, at least, as one sees the courts doing their best to grapple with the other language. And in a way, what's happening, which is most interesting of all, is the IPCC emerging as this kind of shared point of reference, both for climate science policymakers and also for human rights and other international courts. Because the one thing everybody can agree on is that when the IPCC says something, we can treat that as knowledge. Now, whether it actually is knowledge or not is a separate question, but the process that the IPCC engages in is so thorough, so rigorous, so beyond any other knowledge-making process we have at an international level, that it creates this authority, a sort of a global authority in and of itself, which I think is fascinating. It's got more authority in the sort of Arendtian sense than the Security Council has. You know, the Security Council is just a bunch of people who want a war. And they're clearly politically motivated, but the IPCC in principle is not. So that's what I expect to see happening in these cases. I expect to see them drawing heavily on the 6th assessment report and the 1.5 report, and doing their best to frame the statements in those reports as human rights relevant, and thereby creating a context within which other courts, other legislators can sit on that science and say with some certainty, this is what's happening, this is what we have to do. Unfortunately, the IPCC itself is subject to a political process. It tends to be very conservative for all sorts of reasons, and it is unlikely to provide us with language which will be strong enough to meet the kinds of concerns that human rights activists will have looking at the climate problem. So there's that kind of gap, right? And that's where I think you're going to find courts moving, and I hope doing their best. Like I say, the European Court has really, I think, set the clock back with this one, and I'm not sure why people haven't noticed that. I guess we don't want to notice it. We want to look on the bright side, but the unwillingness to say anything on the substance is very concerning. And if the ICJ and the Inter-American Court, is usually a bit more courageous on these things. The ICJ perhaps too. Anyway, you see the problem. The other side of it being, of course, that the stronger a statement you get from the courts, the more likely it is a powerful state refuse to abide by it, and the court's authority is shaken by that. Yeah, but I guess where I would end there is it is a question of authority, and this is why, weirdly, courts will lean on the IPCC much more than the IPCC will lean on courts.
So we have a little bit of time left. Maybe in a couple of minutes, we have two questions. Do you see a chance that the General Comment 26 to the UNCRC opens up possibilities for litigation? This is one question. And the other one is, this is from Christian Zauner. And Lukas Strubel, who will be presenting later as well, asks if, how do you think that climate remediation techniques such as carbon dioxide removal fit within this framework of justice considerations in terms of corrective justice?
Well, let me talk about the second one. On the first one, I think the CRC in lots of ways looks like the more interesting of the human rights bodies, and can do a lot with, I think, the more concrete notion of children's rights, to my mind, than future generations. They speak both languages. But the children alive today, of course, are going to be alive, hopefully, right through to the end of the century. So we can encompass a whole broad spectrum of policy within the rights of these present generations. And I think the CRC are attuned to that increasingly. But they share the same limits, I think, as you see in other human rights organizations. On the CDR thing, so it's so interesting. And yeah, this is an area that I'm looking at myself at the moment. A problem that I would have raised had I gone through my last slide on mitigation, which I think is quite important here, is the degree to which mitigation policy tends in the direction of shutting that development freeze problem, shutting down the capacity of developing countries to use fossil fuels in future to fuel their development. And it's a practical problem because it means that climate impacts are likely to have worse human rights effects in those countries. But it's also a political problem because as countries like India, for example, become increasingly confident on the world stage, they can see what's happening. They can see the bad faith of Western companies in continuing to allocate emissions quotas to their own corporations and not make up the difference with significant transfers to other countries. It's an outrageous way to behave, given the history both of colonialism and of climate change. And people in the rest of the world are not fooled by it. They're just not fooled by it. The real worry is you get a sort of a breakdown in international understanding of what a proper global carbon budget should be. Okay, so I think at the back of the question is this question of a global carbon budget and who gets what. And what's actively happening is that Western countries are taking it for themselves. That's basically what's happening. Now, when it comes to something like a CDR, in principle, it expands the budget. Right, so the idea at some level is, well, we can, the more of it we bury, the more we can then put out. So it eases things a little bit. Politically, of course, that's helpful because it might provide a way of trying to keep people within an otherwise straining regime. But the problem is, I think somewhere along the lines that, practically speaking, so if you look at the IPCC writing on this, The amount of emission reductions we need right now is somewhere in the region of 52 gigatons per year of greenhouse gas equivalents. The amount of foreseeable CDR by 2050, when we're supposed to hit net zero, is something in the region of 6 gigatons. So it leaves you with 45 gigatons of carbon. It's just not going to get you very far in and of itself. If it has the effect of slowing down our actual reduction of greenhouse gases, it's more of a problem than it's much more of a problem than a help. The second side of it, of course, is that actual CDR, sticking carbon into former seams, coal seams, petrol seams, and gas seams, is a technology that's in the hands of fossil fuel companies. And they've been using it, as some of you will be aware, in enhanced oil recovery over the year, ever since the 70s, sticking carbon dioxide back into oil seams to push the oil out. So it seems odd to me that we would hand this power to them. It's both a power of technology and a power of access. It's acquired rights again, because they're there on site in these places, and strengthens their hand politically, because they fail to be, they stop being the bad guys, right? I think it's quite important to remember these are the bad guys, okay? So for all sorts of reasons, I'm concerned at how that will play out over time. More because I think India and other countries, Saudi Arabia has already made it clear, I mean, they're a special case in lots of ways, are not going to play along. They're not going to play along. Why would they? Russia's not playing along. Russia's doing something extraordinary from this point of view. Canada's not playing along, for that matter.
Thank you very much. With this, we conclude your presentation and your answers. Thank you very much for your participation.
My pleasure. And enjoy the rest of your day. And I'll try and I hope to see more of it as I'm here.
Thank you.
Bye now.
See you. And the next presenter would be our Professor Vasilka Sancin, who is a professor of international law and the head of the Department of International Law at the Faculty of Law in Ljubljana, at the University of Ljubljana. She's the directress of of the Institute for International Law and International Relations, and is in the selection process of selecting the new Slovenian judge for the European Court of Human Rights. Next to all that, she also finds some time to be my mentor for my doctoral thesis, for which I am very, very grateful. Professor Sancin was also a member of the UN Human Rights Committee between 2019 and 2022. And in today's presentation, she will address certain interesting developments within this UN committee. Thank you very much for joining us, Vasilka, and the floor is yours.
Thank you very much, Alyosha, for this overly kind introduction. I would also like to start sharing my PowerPoint presentation, so I hope I succeed. Here it is. I hope you can all see it. And before I delve into the topic that was designated to me, I would just like to again thank Alyosha for organizing this very important educational events and for all the efforts of him and his team invested in raising awareness about these very important topics, not just domestically, but also internationally. So thank you, Alyosha, very much for that. So I was asked to speak about the little bit about the practice of the UN Human Rights Committee when it comes to issues of climate change. But before doing that, I would just like to add something to Stephen's response to the last question about the carbon dioxide removal techniques, just to point you to the report of the UN Human Rights Council's Advisory Committee, in which I am now serving, which was published it was published last year, and it is titled Impact of New Technologies for Climate Protection on the Enjoyment of Human Rights, in which the advisory committee actually opined that at the current stage of development, all these new technologies intended for climate protection are not climate neutral, and actually suggested a moratorium unless it is proven that it would actually have more positive impacts on the environment than negative ones. So just to point you to this report for anyone who is interested in reading it. Now turning to the different animal, which are the treaty bodies that are established on the basis of various human rights treaties adopted within the United Nations. I think it's important to note that members of these committees act as independent experts, so they are not representing their governments, but actually act as independent experts and are usually elected for 4 years. This is also the case for the Human Rights Committee. And the mandate of these committees, including the Human Rights Committee, is to monitor implementation of the core human rights treaties, which they do through periodic reviews of the state parties, which is a procedure that evolves over several years. And finally, the constructive dialogue takes place in Geneva at the headquarters of the Office of the High Commissioner for Human Rights. Then there is a possibility for individuals to submit complaints to these bodies. Not all, but Human Rights Committee is one of those, subject to acceptance of such jurisdiction of the committee, which in the case of the Human Rights Committee means that the state had to ratify not only the International Covenant on Civil and Political Rights, but also its first optional protocol. If the committee then proceeds with meritum decision on the case, it adopts the views, and these views, although not binding as a judgment of a national or, let's say, regional or international court, has a significant weight given that all the states are expected bona fide to comply with the recommendations issued in these views, as they have accepted this by ratifying the optional protocol. Then the committees also adopt general comments, or they're called recommendations in case of 2 committees, in which they provide authoritative interpretation of the obligations arising out of these core treaties. And many states ascribe great weight to these general comments. Some in domestic legislation even recognize some legal weight to these general comments. Perhaps important to note is that also the International Court of Justice in its jurisprudence, particularly in the Ahmadou Saado Diallo case, also recognized the importance of these general comments for interpretation of the rights under the relevant treaties, which might be particularly pertinent in the context of the now ongoing advisory proceedings on climate change obligations of states. Finally, there is also a possibility of states to bring interstate communications before certain committees. Although this is rarely used in practice, there have been some examples before the Committee on Elimination of Racial Discrimination, but none yet before the Human Rights Committee. Now, turning to the issue of climate change and the work of human rights treaty bodies, I would like to note that several have already engaged in these topics at various stages, both when reviewing states parties as well as when deciding on individual complaints. Also, they have been adopting general comments which have been touching on the issue of either environmental considerations, but also more explicitly climate change. Particularly, I think it's important to mention the recent general comment adopted by the Committee on the Rights of the Child last year. This is general comment number 26 on children's rights and the environment, with a special focus on climate change. Since I will not be going more into detail of the work of the Committee on the Rights of the Child, I just wish to also note that the committee had the opportunity to decide on the individual complaint that was brought to it by Saki and others versus Argentina, and that in that case, the court found the complaint inadmissible due to the non-exhaustion of domestic remedies. And I think that was quite an important precursor to what then followed also in the more recent decisions before the European Court of Human Rights, where this argument was also used by the court in the cases presented to it. For those who are interested to perhaps have a more comprehensive overview of what the committees have been doing on these issues, there have been various studies presented. I just refer on one of those here on this slide. Now, going more to the work of the Human Rights Committee. First, as I said, the committee has engaged in the issue with the issue of climate change, both in its periodic reviews of states parties as well as deciding on individual complaints. But it has also adopted one important General Comment 36 on the right to life, to which I will refer in a moment. Before doing so, I wish to stress that before encountering, let's say, complaints claiming human rights violations due to adverse impacts of climate change, the Human Rights Committee had the opportunity to engage also in complaints alleging violations of human rights due to adverse impacts of environmental degradation. And in that sense, because I will have no time to go more in depth to these cases, I would just like you to like to refer you to two cases. One is Portillo Cáceres versus Paraguay, and the second Benito Oliveira and others versus Paraguay, which set an important scene, let's say, for the later decisions on the more climate-oriented cases. Now, the General Comment that I mentioned, General Comment 36, is important for the topic, especially because of its paragraph 62. Namely, in paragraph 62, the Human Rights Committee pointed out that climate change, in addition to environmental degradation and unsustainable environment, is one of the most pressing and serious threats to the ability of present and future generations, and here we have this element of future generations as well, to enjoy the right to life. And it explained that this includes also life with dignity. So not just physical existence, but the existence of a certain quality, if you will. And adverse impacts of climate change, of course, have significant effects on the quality of life of people in many parts of the world already, and this will continue to happen as we go ahead. And finally, at the end of this paragraph, also specifically called on states to pay due regard to the precautionary approach. And again, I think this is an important indication of what should be the elements taken into account when interpreting human rights in a, if you will, harmonious manner, if we are talking also about the European Court of Human Rights interpretative methods. Now, the engagement with climate change implications for human rights basically started with periodic reviews based on this General Comment number 36. And by now, the committee has adopted many concluding observations for states that were under review, including specific recommendations referring to climate change. I'm here just for the purposes of presenting two examples, mentioning the periodic report of Kenya, the concluding observations on this report, and also for Germany, where the Human Rights Committee specifically referenced also the Federal Constitutional Court's decision as a very, let's say, important, far-reaching decision, although there are different views among even German lawyers as to what the court did in this particular case. Going now to a more perhaps directly relevant decisions of the Human Rights Committee for Climate Change Concerns, I would like to refer to the two examples, Janete Toita versus New Zealand views and the views in the based on the complaint brought by Billy and others versus Australia. I'm very cognizant of the time, that's why I'm going a little bit fast, so I hope there will be some time for questions as well. The case of Mr. Toita is considered as the first human rights treaty body decision directly addressing the human rights implications of climate change. And what is noticeable in this case is that Mr. Teitoita, who was represented by a counsel, decided to argue only violations of his rights under Article 6. So that means right to life. And whether this was fortunate or unfortunate, it's hard to say, but having been a member of the committee at the time of the decision-making on this case, I can reveal that there were some discussions on what could have been, you know, let's say, assessment of various evidence and arguments had there been other articles argued in the case. The facts of this case is that Mr. Teitoita, together with his wife, moved from the Kiribati, which are significantly impacted by adverse climate change implications, to New Zealand. While living in New Zealand, they had 3 children. So the 3 children never had any contact with the living conditions in the Kiribati. And when they were discovered of staying illegally in New Zealand because they didn't resolve their status in New Zealand, they applied for asylum. When their application was denied, they were eventually removed to the Kiribati. So they have exhausted all available domestic remedies in New Zealand. And now when they complained to the Human Rights Committee, Mr. Teitoita actually wanted to bring the complaint on behalf of himself, his wife, and the children. The problem was that it was only Mr. Teitoita who signed the power of attorney for the counsel to represent him before the committee, which is why the Secretariat of the Human Rights Committee decided to register the case for Mr. Teitoita alone. I personally have certain, let's say, troubles with this decision for reasons that when a parent is bringing a claim on behalf of the underage children, that should, without their signature, be recognized as a complaint brought on behalf of the dependents as well. But that was the fact of this case. So in this case, where the Mr. Teitoita, through his counsel, was arguing that the island of Tarawa, which is one of the islands in the Kiribati, have become uninhabitable due to contamination of drinking water due to the sea level rise, then land disputes because of, obviously, lack of arable land due to, again, sea level rise, and many other reasons. He said that returning him to the Kiribati actually violates his right to life, as he will have no possibility to have a life with dignity in the Kiribati. In order to decide these so-called expulsion cases or refoulement cases, the Human Rights Committee established certain standards to look at. And the Human Rights Committee always looks at whether there are substantial grounds for believing that there is a real risk of irreparable harm. And this risk must be personal and cannot derive only from general conditions in the receiving state, except in the most extreme cases. So it's a high threshold for providing these substantial grounds to establish this real risk of irreparable harm. In this assessment, all facts and circumstances are considered, including the general human rights situation in the country of origin of the complainant. But now the crucial part is the test. The test is that essentially it is for the organs of the states parties to the ICCPR to examine the facts and evidence of the case in order to determine whether such risk exists, unless it can be established that the assessment was, and now the 3 possible reasons, either clearly arbitrary or manifestly erroneous or constituted a denial of justice. And I'm emphasizing this because the Human Rights Committee cannot decide the case de novo, so to say. It is more or less limited to written proceedings, although theoretically it could have a possibility to organize oral hearings, but that is very rare to happen. And based on the fact that it has only, as I say, submission complaint by the author, as well as responses, observations by the government, it has very limited possibility to engage with this evidence and information as presented. And therefore, this very stringent test, it has to be clearly arbitrary, manifestly erroneous. Just an error is not sufficient, or it has to constitute a denial of justice. Now, based on these standards, the Human Rights Committee in this case determined that New Zealand had not violated his rights by deporting him back to the Kiribati. Nevertheless, the New Zealand authorities, already in domestic proceedings, and then the Human Rights Committee also following these arguments in its decision, recognized that the climate change adverse impacts on the living conditions of someone can trigger the non-refoulement obligations of the sending states. So this, in a way, responds to the discussion whether, people displaced due to climate change effects enjoy the same right of non-refoulement as refugees, for example, under the Refugee Convention. Both the New Zealand domestic authorities as well as the Human Rights Committee very explicitly expressed the view that actually the non-refoulement does protect these people in general, in principle, displaced due to climate change. And another very important point in paragraph 911 of the views in this case is that the committee said that not only states, domestic authorities, are responsible for taking the necessary measures to mitigate and adapt to climate change, but that there is a need for international efforts as well. So if you look at the beginning of this paragraph, the committee said that without robust national and international efforts, the effects of climate change may expose individuals to a violation of their rights. By including this explicit language, it was somehow sending a message to the states parties to the covenant that perhaps in the future, if they will not engage in these international efforts, they might share responsibility for the individuals who will be displaced due to climate change effects. And if they will not invest in terms of not just financial means, but otherwise as well, they might violate their obligations under the covenant. And why? Because the situation of having an entire country submerged underwater due to climate change is such an extreme risk that the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. Again, I think a very important pronouncement, because here the committee said we don't need to wait for these individuals to already become a victim in a classical sense of the term, but we can consider them as victims when this threat is so present and imminent that the obligations of states are actually triggered before this risk is realized. Now, in this case, I also appended my separate dissenting opinion, because I felt that the treatment of the domestic authorities in New Zealand, of the argument of the applicant, of the complainant, that they will have no access to safe drinking water, which will seriously jeopardize their life with dignity, has not been given due consideration. In fact, that the treatment of domestic authorities of this argument was arbitrary, or clearly arbitrary, or manifestly erroneous, and that for these reasons the committee should have found a violation of Article 6 that New Zealand decided to return Mr. Te Toita back to the Kiribati without seriously considering this argument. And what was interesting in these discussions in the committee is that many of my colleagues on the committee were not really sensitized, I would say, about this important difference between the potable water, which is what was the government's language and even the language used by the Human Rights Committee, and the right of access to safe drinking water, because even potable water can lead to the living conditions which could not be considered as dignified under Article 6. Now, moving quickly on to the second case, which is perhaps even more important, the so-called Torres Strait Islanders case, Billy and others versus Australia, which was decided in 2022. Torres Strait Islanders is again considered the first human rights treaty body decision finding violations for human rights impacts of climate change. The petitioners are members of indigenous peoples, Torres Strait Islanders, adults and their children. The claim was brought on behalf of adults and the children against Australia, so highly industrialized state with significant contribution of greenhouse gas emissions with limited, let's say, measures of mitigation. There were a number of interventions in this case, and this is also an important detail because it's not very often that the proceedings before the Human Rights Committee will see third-party interventions, but this is one such case, and also the Special Advisor for the Right to Clean, Healthy Environment intervened, as well as some others. It is a case of, I would say, strategic litigation. And for this reason, I would guess there were also a series of human rights violations argued, which is always better, I would say, because then you have better chances to succeed with at least some of them. And again, in the interest of time, I will just focus on the finding of this case. Basically, what is happening is, again, the sea level rise and the effects on the length of the Torres Strait Islands, which impacts the life of these indigenous peoples. Now, in this case, an interesting, again, fact was that the state party, Australia, argued that there are no domestic remedies available that petitioners could use to argue their case. Australia is one of the few countries that doesn't have the list, the catalog of human rights in its constitution or any other relevant legislation. And it was the argument of the state party that there exists no available domestic remedies for this particular case. And I'm emphasizing this because this was the reason why the Human Rights Committee, in fact, did not engage with the issue of exhaustion of domestic remedies. When the state party argues itself that there are no such remedies available, the Human Rights Committee will not go proprio motu contradicting the position of the state party. And for this reason, the committee found no issues with admissibility of the case, admitted the case, and then decided it on the merits, contrary to what was the case before the European Court of Human Rights, where the non-exhaustion of domestic remedies was one of the main arguments of the states in Duarte Agostinho versus a number of states to the convention. So the committee found a violation of two articles. Article 17, right to family life, private family life, and Article 27, given that indigenous peoples also enjoy rights of their cultural life. Article 27 refers to the rights of minorities of the ICCPR. So this is a particular issue, let's say, because we are dealing with an indigenous people. However, the committee did not find a violation of Article 6, right to life. on a very tight, let's say, vote. 5 separate opinions were appended on this issue. Not everyone who voted against appended a separate opinion, so it was a really tight vote that Article 6 was not found to be violated in this case. I was still there at that time. And to my regret, the committee also decided not to decide, it was the decision not to decide on the claims under Article 24 of the Covenant concerning rights of children of these indigenous peoples. I'm regretting this because I feel that although right to family life under Article 17 does concern also children, but there are particular also rights of children that could have been assessed based on the claims brought by the individuals. Now, what we see here is very similar with what happened in Klimaverein Seniorinnen, now before the European Court of Human Rights. The European Court also decided to find a violation of Article 8, which is similar to, let's say, Article 17 in certain respect. But contrary to what the committee did, and that is perhaps a little progress, decided not to decide on Article 2. So in this case, the Human Rights Committee found no violation of Article 6, but in the European Court of Human Rights case, the court decided not to decide on Article 2, which perhaps is a little progress in that respect. So the separate opinions, partially dissenting opinions, I will focus only on those, and especially the one that I joined, together with my colleagues Marcia Kran and Arif Bulkan, we explained that what we think happened in this assessment in the committee is that the wrong standard was used, basically. That the committee was too focused on the standard that it uses in the so-called non-refoulement or expulsion deportation cases that I explained earlier. So, a real and foreseeable risk, whereas we felt that the standard that should have been used was more a reasonably foreseeable threat. And that based on this factor, if it would have been applied, that the committee would have had to recognize that there are certain effects on the life of these individuals, and there is a serious threat, clearly foreseeable threat for the lives of these individuals, and that this should be assessed separately from the risk to their right to enjoy their culture. So we strongly felt that there was a missed opportunity for the committee to pronounce on Article 6 violation, and especially failing to consider also the precautionary approach, and that there have been, as I said, effects already existent at the time of the filing of the communication of the petitioners, and that based on this, the committee should have decided on the violation of this right as well. So I'll stop here, and I'm looking forward to the discussion. Thank you very much.
Thank you very much for the presentation. We have the first question here. So our Luca is asking you, which formulation of the precautionary principle would you advocate for when considering the implementation of the right to life regarding environmental pollution, as enunciated in the comment number 36?
Yeah, so this is one of the issues that everyone is approaching with certain caution, also in the Human Rights Committee, because obviously we know that there is no universal agreement on how to interpret the precautionary principle. I think that what the Human Rights Committee meant in including this principle, but again, I was not there when the General Comment 36 was being adopted, so this is just my interpretation, is that this link to lack of certainty, but certain foreseeability of a serious threat. So when there is a, let's say, significant scientific evidence, although it is not absolutely certain, but the risks are serious. I mean, serious risks are reasonably foreseeable. The states are to both, of course, act in a way not to violate their negative obligations, but specifically also that they have some positive obligations. And I think that this concept of positive obligations have come clearly out also in the recent decisions of the European Court of Human Rights, where in Klimaverein Seniorinnen, at least what the court found is that these positive obligations had been violated, although on a more procedural, let's say, level. And this is what I think is at the current stage of development, the understanding under this precautionary principle. So the state has to act to prevent to the extent possible, to mitigate and to adapt. And but of course, there will be very different opinions depending on whom you ask in the treaty bodies as well.
Thank you. I have a very practical question, and this is, how do these decisions, in your opinion, in your experience, at the committee level, impact national governments and their actions? And also, what direction perhaps should this decision take? Do you have like a future vision of the committee? What should it be? What should it do in the future?
Yeah, so first to the first part, I think that these decisions certainly do have implications for both domestic regulators, as well as we see the regional courts and perhaps, I'm sure, even for the International Court of Justice. So I think that, therefore, it is not a coincidence that the Human Rights Committee prioritize these two cases. By prioritizing cases, I mean that given that the Human Rights Committee is faced with significant backlog of cases, if these two cases that I discussed would have to wait for their regular turn to be decided, they would not have been adopted, let's say, when they were adopted, but perhaps some years later. And the decision for prioritization was also, let's say, triggered by the fact that there are all these kinds of developments, both at domestic level, at the regional level, and at the global level. And I think in this sense, these human rights treaty bodies, and here I'm referring to also the Committee on the Rights of the Child and others, have the opportunity to somehow provide some guidance to the states, what is expected from them, and also provide some important legal argumentation for other regional courts. Billy and others is now being cited in Klimaverein Seniorinnen, also other cases, of course, but this one has been specifically referred to as a pertinent case to find a violation in that judgment of the European Court of Human Rights. And I certainly expect it to be one of the leading cases for the advisory opinion of the International Court of Justice. So I think it is important to bring such cases to the human rights treaty bodies, although I am fully cognizant of the fact that given this backlog, sometimes petitioners and NGOs, or let's say civil society organizations supporting them in this strategic litigation, are sometimes discouraged to do so, given that it is not certain that these cases will be prioritized, and then if they had to wait for too long, and especially in cases where the non-exhaustion will be argued by the governments, the chances of success are more limited.
Thank you. We have the opportunity for one more, the time for one more question. And Simon Wazwa is asking, in your opinion, how much does the fact that climate refugees are not formally recognized in international legal framework, how much does that influence the ruling of the HRC in respect to Article 6 vis-a-vis climate change?
Yeah, thank you. It does not. As I said, the Human Rights Committee took a clear position that the principle of non-refoulement actually applies also to people displaced due to climate change adverse impacts. when they are capable of demonstrating that serious risk of irreparable harm. But positively in the Teitoita decision is that the committee said it is possible to demonstrate such a risk even before it materializes. So I think in that case, this will definitely, hopefully, I hope personally, it also depends on who sits on each composition of the Human Rights Committee. But I hope that this will be a clear guidance for future decisions. So non-refoulement should be based on the human rights law, not the Refugee Convention, but based on the human rights law, the ICCPR, recognized also for these individuals.
All right, thank you very much for your presentation, for your answers. With this, we would conclude your contribution. And now we will take a short break. I think 5 minutes will be enough. We've been here for an hour and 45 minutes, so let's take a short 5-minute break and return at 11:48. Thank you again, Vasilka.
Thank you for the invitation.
All right, I hope everyone had time for a short break to do everything we have to do during these breaks. And now we will continue with our speakers. The next presentation will be given by two presenters from Climate Analytics, Dr. Lucy Helfman and Dr. Andreas Geiges. I will shortly present both. Firstly, I will present Dr. Lucy, and then I will present Dr. Andres. Before joining Climate Analytics, Dr. Lucy pursued her PhD at Freie Universität Berlin and the Potsdam Institute of Climate Impact Research. In her research, she developed scholastic methods for quantifying tipping paths, and this method can be used for studying tipping in models or social systems or of the climate. Lucy also holds an MSc in mathematics from Freie Universität Berlin and a BSc in mathematics and physics from the University College London. And she joined the Climate Analytics in 2023 and works in the climate policy team, where she contributes to projects such as the Climate Action Tracker through modeling and software development. Dr. Andreas Geiges is also involved in multiple projects, including the Climate Action Tracker and Impact. He has a broad background in stochastic modeling, Bayesian, I hope I pronounced this right, statistical analysis, uncertainty quantification, as well as in information theory, while working on a wide range of model types, including fluid flow, economic, and agent-based models. He has developed a high level of expertise in data analytics and management, conceptual model development, and transdisciplinary work. You are the first non-lawyers speaking today. I would like to welcome you. I hope you are going to give us a bit of a different perspective than was given until now, and the floor is yours.
Yeah, thank you. Yeah, I think we are also curious how this will turn out, because our presentation is slightly more technical. Okay, I will share my screen. Okay, I hope you can see the correct screen. Yes, perfect. So Andreas and me, we will be talking about the Climate Action Tracker fair share methodology. And to give you some background on the Climate Action Tracker, the Climate Action Tracker is a scientific project since 2009 from two Berlin institutes, the New Climate Institute and Climate Analytics. And it tracks climate action towards the Paris Agreement target. And one of its main outcomes is this thermometer that you can see on the right-hand side now. And this shows the implied warming of countries' actions, such as, for example, countries' NDCs, which would lead to 2.5 warming by the end of the century, according to our calculations, or also countries' current policies, which would lead to 2.7 degree warming by the end of the century. So as you can see, this is quite far away still from the 1.5 Paris Agreement goal. Another big outcome that we have is that we also assess countries' fair pathways and also feasible pathways. And in this talk today, we will introduce to you the methodology that is behind computing these fair emission pathways of countries. As you all know, like climate targets should be fair, and this is part of the Paris Agreement. It says that NDCs, so the nationally determined contributions, should consider the common but differentiated responsibilities and respective capabilities of countries. But there's no agreement on how such a fair contribution should be defined or should be computed. And because of that, scholars and government experts and also civil society have contributed many different approaches on how to compute such fair emission pathways for countries. And some of them are very contradicting, actually. And so there is a problem on consensus. And what the Climate Action Tracker, so the CAT, is therefore doing in its methodology is it's taking into account all these different approaches and tries to find a synthesis from them. It tries to take them all into account and produce one emission pathway that is fair for each country. And yeah, in this next slide, I want to give you like a short background on these different approaches and why there are so many different approaches. And one reason why there are so many different approaches is because there are different principles that are underlying them. And these principles can be categorized according to this paper from Höhne et al. 2014. And I've listed some categories here. So one category is responsibility, and approaches in this category, they say that emission reductions of countries should be higher for countries which have more responsibility for global warming. So countries which have higher past emissions. Another category is capability, which says that emission reductions should be higher for countries with more economic capability. Some other approaches say that emissions should be equal per capita for all. And there are some other approaches that I'm not listing here that, for example, also take into account the right to development. But there are also approaches that we at the CAT do not consider as equitable, such as these approaches from the cost-effective category, which consider least cost pathways as equitable. But these we won't take into account. But yeah, because of these different underlying principles, the fair emission pathways can look quite different. But another reason why they can look quite different is also because they can be computed or implemented in a different way. And there are basically two approaches for computing fair emission pathways for countries. One approach is allowance sharing. And there the idea is that the remaining carbon budget, the remaining allowances to limit warming to 1.5 degrees are shared in equitable way among all countries based on these different principles. And the other approach is to share the burden, to share the reductions that are necessary in an equitable way. And here the burden is basically defined as the reductions that are necessary to go from a hypothetical business as usual scenario down to a 1.5 compatible pathway. And yeah, to now share either these allowances that are remaining or this burden that is necessary in an equitable way, usually we use indicators from these different principles. So an indicator for responsibility would be the historical emissions, because this basically represents the responsibility of a country. Whereas the GDP of a country would be an indicator for capability. Okay, so now, because of the reasons that I've discussed now, there are many different emission pathways that are fair in the literature, and the CAT is trying to take them all into account. And we try to take them into account by defining the so-called equity range. So we take all the approaches from the literature, or most of the approaches from the literature, and they give us allowances for each country, and then we map them on a line as shown here. These crosses are different fair allowances from different approaches for one given country and for the year 2030. And as you can see, they are quite different. They span a range. And from this, we define the so-called equity range, which for us is where the majority of data point lies. So we exclude some allowances that are maybe extreme. And this is now the equity range for a given country, but different countries will have different equity ranges. So of course, like countries that are more capable, they should have equity ranges that lie near lower emissions, but also countries with higher responsibility have equity ranges that lie near lower emissions. But then on the other hand, also countries which are bigger, that have a higher population, they of course have higher equity ranges. Yeah, because of these different reasons, countries have different equity ranges. But of course, what we are interested in is not like a range of fair allowances for a country, but one specific fair allowance value for a country. And yeah, therefore we have to somehow like reduce this. And it's also interesting to note that this range for each country is quite wide. So if every country would choose the upper end of its range, which corresponds to the allowance that is most suitable for them because it gives them the highest allowance, then we would reach 4-degree warming. Whereas if every country would use the lower end of its range, which is the most, like the strictest approach that exists in the literature for them, the world would end with something like 1.2-degree warming. So this range is really wide, and we have to find like a value, like a point in this range that is somehow fair and also respects a certain temperature target that we are interested in. And we are usually interested in limiting warming to 1.5 degree, or maybe also to 2 degrees warming. Yeah, so how do we get to this value? And for this, we define the equal level of ambition. So we want to respect the individual circumstances of countries, which are given basically by this equity range. But to find a specific point in this equity range, we ask for an equal level of ambition. And what we mean by this is we ask for that all countries take a comparable position within their own equity range. So for example, in this figure here, all countries are at, let's say, 75% of their equity range. Yes. And then, but as I said, we are then interested in a certain temperature target. So we have to then vary this comparable position, the 75%, to maybe to 50% or like to other values to find the value where we limit warming to, let's say, 1.5 degrees or 2 degrees. And we have to do this for all countries at the same time because all countries together influence the global warming. Yeah, and Andreas will now go more into details on how we do this.
Okay, so yes, also welcome from my side. Please, I'm sorry for my voice. I have like a mild cold. Yeah, so far, as Lucy explained, we needed for like assessing like the individual action of a country, we always need to assume what other countries do, because we can only make a picture, like we can only relate it to global warming if we have like the global picture. Therefore, we have this equal level of ambition. And I think that is in the beginning a bit strange, but it basically makes assumptions how like that countries act like similarly. And this is just like an overview, what happened. So from the whole pipeline. So as Lucy explained, we start from this fair share data set, which is coming from literature, and we want to come to a rating scheme. So on the right, you see what the climate action has defined as like the different rating levels, and it's basically defined by temperatures. So the Paris Agreement compatible is like the green one, and then we have 2 degrees, and then actually go in 1 degree temperature steps up. And yeah, we name them appropriately. But basically what you need to know is basically that these categories are cutting in that fair share range, which is a relative scale for each country. So you put all countries on the same relative level. So when we go to the next slide, yeah, as you've already realized, this is all like quantification, which is very technical, and I'm sorry that this continues like that, because now we need to find a level which is actually consistent to this temperature levels. And as also Lucy mentioned, now what you've seen in this range, we actually now need to repeat for all countries where we have data. We use baselines for small countries where, for example, we don't have any equity data. And then we also do that for in 10 or 5-year steps. So we do that for 2030, 2040, and 2050, and get like a level, like 3 levels where we can interpolate. And then we add like historic data. And then we also need to do like an extension to 2100 because the framework where our climate model works, this works basically from the past to 2100. And then with that one, with historic and an extension, we get like a full data set for a country. And then again, we do aggregate all these country emissions to like a global pathway. So there's a summed allowance pathway plus an extension. And this green pathway, of course, depends on what level we choose in these ranges. To complete the picture, we need to add land use and land use change emissions because they are historically a bit detached from national emissions. And also bunkers data, which is defined like as aviation, international aviation in international shipping. So these contributions are basically held constant while we look at what nations need to do. And with that one, we basically get a Kyoto gas pathway. But since our climate models run with various gases, we basically have a statistical estimation scheme, which then gives us all the different climate active gases. So for example, methane and nitrogen oxide. And with that one, we have a reduced climate model. So these are not these models which run for like a month, but this actually runs in a few minutes. And this gives us a complete warming trajectory. And these small models are basically calibrated to mimic the big models, but we can actually run that a lot of times. And for example, then we have to, on a mathematical level, define what is the Paris Agreement level, and we define it as like a peak warming of 1.5 with a 66% chance. But for example, we relate to the IPCC, so there are other definitions, but it's basically you need to like mathematically formulate what you say, what is achieving 1.5 or like the Paris Agreement. And basically with that one, you get like an iterative loop where you can lower these levels until you actually reach a target which you want. So on the next slide, you basically see that, like as I said, we are lowering these levels until we see globally we reach a target, and we can basically color or map these ranges for every country. So above 3 degrees, below 3 degrees, and then 2, and then actually like a 1.5 compatible range for every country. And basically now we go back to the country and actually look and compare it with the provided NDC of a country. So now we flip this basically from a horizontal to a vertical bar. And then on the next slide, I give you an example, for example, for the EU. So this is basically now a result. So this bar you see is including the fair share range, and it's colored. And then on the black, so I'm sorry, this is from the website. It has a lot more information, but in black, you see the NDC target, and it's falling in this orange range. So this means when all countries would go to the same NDC level, so basically the NDC of the EU defines the level of ambition. So we put all other countries on the same level. And with that one, we would achieve a global warming which is below 3 degrees, but it's actually higher than 2, and therefore it's in the orange range. And like very low, you see in where the border is to the green, this would be actually what we would consider for the EU to be fair in an equitable way. Just to put it in context, this is the right side of our rating. This is based on fair share, and it also has like a climate finance component. But I just want to mention that in the current rating system of the Climate Action Tracker, this is only one part. If you go to the next slide, there's another part which we call based on model domestic pathways. And we do this because, like in the beginning, Lucy said that we exclude this whole perspective of cost effectiveness and feasibility and what is technical possible. This is basically put to another rating. This rating, I just briefly say, this is based on integrated assessment models, and it purely talks about what is technically feasible on a domestic level. And the overall insufficient rating would be like a combination of two. But what we presented so far is only like the right side, but just that you have like the full picture. So on the next slide, Basically, as a conclusion, what I want to, what you have to hopefully take away from that talk is that we try to synthesize existing literature and define like a relative scale between countries, so to make like a mitigation action comparable. And in that range for countries, we identify what levels are enough to, for example, achieve a common target. But it's very important to state that like just being in that range is not enough, because this is for all countries the most favorable approach, and this is not leading to 1.5 compatible allowances. And the Climate Action Tracker basically can rate existing NDCs, and sadly, most NDCs are lying in the 3-degree category, or like 2 degrees. As we know, this is all not sufficient. And then we also provide what allowance would be compatible to 1.5 emissions. It is important to say that the equity framework is a quite theoretical one. So it provides, or it suggests very negative emissions sometimes. So for example, for Switzerland, we like the 1.5 level is very like suggests very negative emissions, and therefore we interpret that these emission reductions also include like financial support for other countries, for example, not in the domestic boundaries. Last year or the year before, there was a big update from the IPCC report, which provides new modeling data. And therefore, we are currently working on an update for our rating scheme. And we are also working on a new publication, which will provide the methodology in more detail. And if you want to find more on the current methodology, I just put like the link to our website where we stated basically, again, what I showed you now. And with that one, I want to thank you all and for the chance to present here. Also from the whole team. So this is like work of a lot of people. So we're very happy to present that to you and that you are interested in it. Thank you.
Thank you very much. If I speak for myself, I am very interested in your work. This was a great presentation, and we already have questions for you. Ina Bertak is asking something that I'm also interested in. She would like to ask what kind of measures are or could be taken to make sure that the data provided by the countries is true to the real level of emissions, so that the goals are truly met.
Okay, I can start. So are you talking about historic emissions? Or just...
From my perspective, is just the input information that you get, that you define the fair contribution on, how, let's say, believable or how good are your models in defining the actual levels? Yeah.
Yes, that's a very good question. And since I worked a lot in uncertainty quantification, I'm happy to talk about that. So of course, models have their uncertainties, and I think climate models have their specific uncertainties because they are modeling something which we haven't observed yet. So I would say my confidence if like defining like what is a 4-degree or 3-degree warming is not that high, because this is like very much going into unobserved territory. But I'm actually hopeful that since the 1.5 warming levels are closer to what we have already now in our atmosphere, that we can be confident. So of course, we only use what science is providing us. So there are, like we all know, there are tipping points, there are unforeseen effects. So this I have to exclude. So we don't know the unknown, but I would hope that if we are really aiming for 1.5, we can be confident that we are actually that warming will be limited to that, or like something similar.
All right. Thank you. The next question is from our speaker before, Professor Humphreys. He states that it was disappointing in the Klima Seniorinnen case that both parties raised the question of fair shares and provided also methodologies, including CATS. but the court did not land on either, or indeed made any attempt to define fair or equitable. Is the professor right that Switzerland's policy falls outside its equity range, which was basically already addressed a little bit? And how can human rights, in your opinion, inform a fair shares methodology?
Yeah, so of course we also followed that case. And I think the problem is that so we also have been involved in, or like trying to explain our methodology, and we are aware that I think the complexity of the methodology is like a critical point. And as we said, like there's no agreement, which is not helping. So I think I cannot answer your questions, to be honest, because it really depends on like what methodology look like, but also what you said, like there are different methodologies and they all like they all point in the right direction. So I think I would say like it's for most countries it's very clear that currently there's not enough be done. But then in the detail, what is now actually 1.5 compatible, I think it's becoming very complicated, because also for us, it's not yet clear how we introduce finance completely, because it's also not clear how much financial support you need to give to countries, and how you would basically account for that. For example, Switzerland as a case, I think Switzerland is also now one of the first countries which includes like financial action in their NDC, which makes it very complicated for us to assess what is like NDC on domestic bounds and what is like international bounds. Yes, so
maybe your evaluation of their approach, this responsibility of Switzerland, which is basically for greenhouse gases reductions per capita. So they took this per capita approach.
Yes, I think the per capita. Yeah, please, Lucy.
Yeah, I would just say that I think the per capita approach is the approach that is more favorable for them, because as I said, we have this equity range for each country, and usually the per capita approach is the one that is at the top end, because it doesn't take into account the country's historical responsibility or capability. It just says that all countries have an equal right to emissions per capita. So usually for big emitters or more developed countries, this is the most favorable approach. And it's of course a problem if these countries rely on this approach, because each of these approaches always assumes that all countries, it only works if all countries take the same approach. So if we share a global budget according to one approach, then this approach assumes that all countries do it according to the same approach. And if Switzerland wants to use the equal per capita approach, but other countries do not want to use this, then the global budget isn't met. Because as I said, as I showed before, if every country uses the approach that suits them the best, the highest end, then we would end with 4-degree warming. Yeah.
Great, thank you. And perhaps the last question for you would be, could you speak a little bit more about how you include climate financing in the consideration of a fair share of a specific state?
Yeah, I'm not an expert on that, because this is basically from another group. But first of all, I think so we will also update that financial component. But we basically currently only make a statement about the quality of the statement. So is a country very clear on its financial support, or is it very vague? And but we so far didn't connect it to the actual need, which we will hopefully change in the future.
All right. I would like to thank you both for your presentations and the interesting information that you shared with us. Thank you again. And now we will move forward to our next presenter. Our next presenter is Dr. Samuel Ruiz Tagle. He's a research bi-fellow at Hughes Hall, University of Cambridge, working as a senior researcher at the Center for Climate Engagement. Dr. Samuel works in the area of public law with a focus on administrative law, planning law, and urban governance. He also teaches administrative law at Cambridge, having previously taught the same subject at Oxford. And his work concentrates on planning law and administrative law, including their overlap with other fields such as local government and climate change law. His most recent projects include the legal role of local authorities in climate governments and the nature of planning law doctrines. Today, he will address climate change in planning law. Dr. Ruiz Tagle, the floor is yours. I hope you have unmuted. You have to unmute yourself.
There it is. Hello.
Great. Hi.
So I'm sharing my screen. Perfect. All right. So thank you for the invitation. So today I would like to talk about how climate change is addressed within states and how domestic legal regimes allocate responsibilities between the central government and subnational levels, mainly local governments. So in a way, my presentation really examines the extent to which the existing legal regime enables local governments to take responsibility for their fair share of emissions or for the emissions created within local areas. So in terms of content, my analysis today proceeds in three main steps. So first, I am going to talk about the Climate Change Act in the UK. So most of my presentation focuses on England. And I really want to discuss how the legal framework or how local authorities fit within the legal framework. And I also I'm going to look at what has happened in practice and what local authorities have done to address climate change. And the second part of my presentation will focus on court cases in the area of planning law and development control, mainly because this is one of the most characteristic areas of local government. And finally, I will offer some remarks. So as some of you may already know, the UK Parliament passed the Climate Change Act in 2008, which creates a general framework for tackling climate change mitigation and litigation in the country. So this act is sustained by four main pillars. It contains a goal, an obligation to deliver climate neutrality by 2050. It also creates a legal pathway to ensure that this final goal is delivered. So, and this pathway takes the form of carbon budgets, right? Which are basically limits on the amount of carbon emissions which can be emitted over 5-year periods. The third pillar of this act involves policies and actions, right, that the government has to adopt across various areas of the economy, for example, in transportation, in the building sector, in energy, and so on. And the final pillar creates a monitoring framework, which is administered by the Climate Change Committee, which is an advisory body. From a legal perspective, one of the key aspects of the Climate Change Act is the fact that all these pillars that I just mentioned are translated into duties and responsibilities, public law obligations, which can be enforced by the courts. So, for example, the Secretary of State is under an obligation to ensure that carbon neutrality will be delivered. It is also, the government is also under an obligation to set carbon targets and to meet the targets defined in carbon budgets. It is also under a duty to prepare proposals and policies for meeting carbon budgets, and the Climate Change Committee is also required to do certain things, right? So we see various duties and obligations. So overall, this act creates an administrative regime, empowers administrative bodies, and creates procedures for climate policy formation and delivery. And in this regime, the main institutions taking part of these actions are the central government, parliament, and the Climate Change Committee. Local government doesn't really feature in the act, so the act is mostly silent regarding what is the function and the place of local government in climate change mitigation and adaptation. And this is a really important point because although local governments create a very small amount of carbon emissions through their own operations, the government has acknowledged that they have the power to influence up to 80% of all UK emissions. Now, the fact that the Climate Change Act doesn't really address the role of local government in this regime doesn't mean that local authorities are powerless. So there are various duties and obligations scattered across various pieces of legislation, which local authorities can use or rely on to adopt climate action. So for example, there is a general power of competence contained in the Localism Act, whereby a local authority has power to do anything that individuals generally may do. This is a very general power. It has limitations in the Localism Act. It has also been limited by the courts, but it is a power that in principle could be used. Local authorities are also under an obligation to prepare planning policies to secure that the use and development of land contributes to climate change mitigation and adaptation. And these policies have to be taken into account in the assessment of development proposals. In terms of procurement, they also have powers to consider environmental issues. And they also have different powers to impose energy efficiency standards, for example. So we see that there are powers and duties that can be used by local authorities, but the main idea is that the existing regime emphasizes local autonomy. Local autonomy, the idea that it is for local autonomies to decide whether to act and how to engage with climate change mitigation. Now, what has happened in practice? So in practice, we see a relatively high level of engagement within the local government sector. So for example, around 120 local authorities have declared a climate emergency. These are political declarations. The legal effect of these declarations is relatively unclear. Some local authorities have developed net zero policies, as I said before, for example, including energy efficiency standards or carbon offsetting requirements in their local plans, in their planning policies. Some local authorities have also developed locally determined contributions and local carbon budgets, for example, in Manchester. So they have defined the amount of carbon emissions which are created within their boundaries. And in general, more than 300 local councils have adopted some form of climate policy. So However, there are some practical problems, right, despite this level of engagement. So a recent study by researchers from the University of Leeds found that most climate plans vary considerably in terms of strength, scope, and specificity. So for example, some climate plans include targets for operational emissions created by the Council and also for area-wide emissions. Other local plans only include targets for operational emissions, and 30 local plans have no targets at all. So there is a high level of disparity. They also found that climate plans do not really specify the trajectory of emission reduction. So they don't really contain interim targets, right? And how those interim targets are to be achieved. And there is a high level of disparity as well in terms of the methodologies used by different local councils. So local councils hire different consultants and they follow different methodologies. Some of them follow the approach adopted by the Climate Change Committee, others follow international approaches. So there is inconsistency in this regard. So the existing regime has also created problems in terms of legal accountability. So as Liz Fisher and Sid Shapiro have argued, legal accountability involves the requirement that public bodies have to explain and justify their actions. And a key form of accountability involves legal accountability, where the explanation is presented before the courts. So legal accountability is important for various reasons. First of all, it is one of the fundamental pillars of the rule of law. Courts also have the capacity to scrutinize administrative action in a more impartial and objective way. And court decisions can also be enforced, right? They cannot be ignored. So overall, in terms of the effectiveness of the existing regime, there is a high level of engagement. However, there is uncertainty about whether the combined emissions reductions committed in climate plans is consistent with net zero. And this is a point that has also been highlighted by the Local Government Association. Basically, this idea that it is unclear the extent to which local councils fit into the national plan, right? Now, I want to focus on the planning context and development control, mainly because the building sector is the second highest emitter of greenhouse gas emissions in the UK, contributing to 17% of total UK emissions, and progress in this sector has remained relatively flat over the last 10 years. As I said, this is a characteristic area of local government, and from a climate change and environmental perspective, it's also a really interesting area because the Environmental Impact Assessment Directive was implemented through the planning regime. So we often see environmental and climate change issues arising in planning. So before examining the court cases that I want to discuss, just like a few ideas about how the decision-making process in this area works. So most development proposals are determined by a local planning authority. So development proposals are assessed on the basis of local plans, which contain policies for the use and development of land. So these policies are not binding, but they have to be taken into account by the local authority, by the planning authority. And The main principle is that planning applications which accord with the local plan have to be approved unless other material considerations indicate otherwise. Planning authorities also have to consider national planning policy, which is issued by the central government, and it is contained in a document called National Planning Policy Framework, which sets out planning policy for the entire country. There is a right of appeal to the Planning Inspectorate, which is a central government agency. The Secretary of State may intervene in some cases, deciding some planning applications and some planning appeals. And there is a separate regime for major infrastructure projects. I am not really considering this regime in this presentation. So the first case that I want to talk about involves a development proposal for demolition and construction of a retail store in Oxford. This was submitted by Marks and Spencer. And the main objector here was the charity Save Britain's Heritage. So they were really concerned about the carbon impacts of the scheme. The main issue was whether the redevelopment of the existing building would produce less carbon emissions than demolition and construction of a new building. So this had to do with the concept known as embodied carbon, of the issue of embodied carbon. So embodied carbon refers to carbon emissions which are associated to the production and transportation of the raw materials used in the construction phase, including demolition, which is different from operational emissions associated to the use of the building, for example, involving the heating or the cooling of the building. So the main objection here was that a comprehensive redevelopment would produce less carbon if we take into account embodied carbon produced by the project. So the Secretary of State refused planning permission for this project based on a policy that I am going to discuss in a moment. But the main idea was that in his view, there should be a strong presumption in favor of repurposing and reusing existing buildings, right? So he argued that the decision maker had not really demonstrated that it was not possible to implement other schemes, or that the developer had demonstrated a compelling justification for demolition and rebuilding. So the developer challenged this decision and was successful on 5 of 6 grounds. In this case, the court had to deal with the legal interpretation of the National Planning Policy Framework, right? So this policy, as you can see, encourages the reuse of existing resources, including conversion of existing buildings. So the Secretary of State interpreted this policy as establishing a presumption, basically what was called a retrofit first approach. So you first have to think about whether this building can be reused, and if not, then you proceed to demolition. That was the authorities' approach. The court decided that that approach was not contained in this policy, that there is some encouragement for the reuse of buildings, but nothing that comes close to a presumption. So the court decided that the Secretary of State had in practice created a test or policy hurdle, which is not included in the policy. So from a wider perspective, this case is interesting because it shows, in a way, the limits of domestic adjudication. The courts are operating within established doctrinal frameworks, and the courts, in many cases, very often, have emphasized that policy guidance have to be interpreted in a very straightforward way, always in their context, and in the process of interpretation, the interpreter should not add words that are simply not in the policy. The court was aware of the importance of the issue, but it held that this case was not about whether it would be appropriate to have a policy addressing embodied carbon. This was a matter of straightforward interpretation of the policy according to general principles. The second case involves a planning application for the expansion of a regional airport in Southampton. And this involved the extension of the existing runway and the car park. So here, the objectors were really concerned about what they call the contextualization of greenhouse gas emission. So their main point was, how do we define whether the greenhouse gas emissions created from a project are significant? What are the benchmarks? What are the criteria used by the decision maker to define this issue? Here, the developer had concluded that the project would add only 1% of emissions to the level projected in the UK aviation forecast. And the planning authorities accepted that analysis and concluded that the scale of the project was so small that it would not hinder the ability of the central government to deliver net zero. So here, this challenge was dismissed. And it's also interesting because the court had to grapple with the issue of acceptability of carbon emissions, right? And the court held that this issue is not addressed by the environmental impact assessment regulations, and therefore it is for the decision maker to decide as a matter of expert judgment which benchmark and which criteria are to be used to assess significance. So the decision maker can decide using national carbon budgets or sectoral figures or local carbon budgets, but it is for the decision maker to decide this issue. So in this case, the court agreed with the approach adopted by the local authority. So again, in this case, we also see how the gap in the existing framework plays a role, right? And how the courts act on the face of such regulatory or legislative gaps. The third case also involves an airport expansion in Bristol. So this planning application involved a capacity increase from 10 to 12 million passengers per year. So planning permission was submitted to the local authority. The local authority refused planning permission, and on appeal, planning application was granted. So the claimant here was a network of environmental organizations, including residents from local communities affected by the expansion. They were also concerned about the carbon emissions from the project. And one of the main arguments that they raised was that the proposal would consume the totality of the local carbon budget for the entire local area. So I think that this is a really interesting point. They raised other issues, but this is interesting. So here they submitted evidence from academics who calculated the carbon budget for the entire area. And they also defined the extent of the impact of the expansion on the local budget. On appeal, this argument was dismissed. And one of the main arguments that the planning authority relied on to dismiss this claim was the fact that local carbon budgets have no basis in law or in policy. They are not regulated, right? So here the court had to grapple with the issue of the appropriate level of decision-making to assess the significance of aviation emissions, right? And the court also agreed with the approach adopted by the local authority and decided that the fact that local carbon budgets have no basis in law or in policy was significant. So it was appropriate in this case to assess the significance of greenhouse gases in the national context. So what can we learn from these cases? So all these cases grapple with gaps in the statutory and policy framework, right? For example, gaps in relation to embodied carbons, gaps in relation to which criteria to use to assess significance of greenhouse gas emissions, or gaps in relation to local carbon budgets. So the courts are constrained in their decision-making by existing legal doctrines, right? And they have little room to maneuver within those doctrines. So for example, one of the main doctrines governing judicial review of environmental decisions is the idea that decision makers are granted a wide leeway to exercise expert judgment and professional assessments based on scientific evidence, where the courts are really, really unlikely to intervene. So litigation cannot always be a substitute for good legislative and policy frameworks, right? So, and to address these gaps, what's needed is a more systemic approach, looking at the ways in which legislation can ensure that local government action is aligned with national targets, while allowing local governments to tailor their actions to their own local context. Thank you.
Thank you very much for your presentation. These were some very interesting cases. I can already think of some. Can you hear me? I hope.
I cannot hear you. You're muted.
I don't think so. You can just let me check. Okay, the others hear me, so the issue is probably on your side.
Hello?
Yeah, we can hear you.
Okay,
Can you hear me? Okay.
Yes, I can hear you.
All right. Thank you very much for the presentation, for your contribution. You had some very interesting cases, and I'm already thinking about the local issues we have here in Slovenia as well regarding planning, and especially carbon budgets. Maybe if I can take the first question. How do you see the responsibility of local authorities for tackling climate change if they don't have a local carbon budget set? What would you say is the next step?
How they can take responsibility if there is no local carbon set?
Yes, if there's no local carbon budget.
I think that's the main issue. Mm-hmm. That's basically one of the main issues that I am trying to discuss in my presentation. So carbon budgets are a way of allocating responsibilities, right? So, and we can allocate responsibilities to central government through nationally determined contributions, or to local governments. So it's really difficult to allocate responsibilities without a carbon budget. Local authorities do have, as I mentioned, other tools to contribute, right, to climate change mitigation. But it is not possible to quantify the extent of those contributions or the effectiveness of those contributions without a carbon budget, right?
Thank you. Because we do not have even a nationally determined carbon budget, so this is something that I can use for further advocacy work. Thank you very much. And now we have the questions from Ena Bertok. How do you propose local government empowerment in climate change policy in less developed countries if we face this much difficulty in implementation already in the UK, as you stressed? Is this even possible? What are your thoughts?
So yeah, this is an interesting question. There is definitely an administrative capacity problem, and I think that this is irrespective of the country, right? So there are questions of capability, economic capability, and lack of skills. So one way of lifting this burden from the shoulders of local authorities would be to centralize to some extent. This is it can be a contentious opinion, but as a degree of centralization of some tasks would be helpful, right? To concentrate some tasks at least in the hands of the central government. So, for example, in the case of the UK, in the hands of the Climate Change Committee conducting assessments, expert analysis, right? So that to avoid that every single local authority has to, hire consultants and spend resources that they do not have on this matter. So I think that could be one way of doing it from a governance perspective, or from the point of view of the design of the regime, to centralize some issues, basically. Perhaps to centralize those issues involving expertise and capacity, right?
So expert knowledge.
Yes, I think, expert knowledge.
Thank you. And Matthias Žvokel is interested in how the British Overseas Territories and Commonwealth of Nations are affected by UK climate change policy. Do you have any opinion on that?
Not really sure I can comment on that. So I'm really looking at the basically Climate Change Act in the UK, and even in the UK, different nations have different climate regimes. So I am mostly focusing on England. So there is a different regime in Scotland and in Wales and in Ireland, right? So for example, Scotland has a duty on local authorities to consider certain aspects of net zero. So, yeah.
All right, thank you. I think that answers the question. And then our Luca is asking you, do you perhaps know what approaches are the local governments in the UK taking, the ones that have the carbon budget, to allocate the national carbon budget to the national level?
I think so. Yeah, good question. So I am not entirely sure whether local authorities that have adopted local carbon budgets have or are thinking about the domestic contributions of the entire country. I think that they are, in some cases, using methodologies developed at the international level rather than domestic methodologies, if it makes sense. So I think that they are looking at the Paris Agreement rather than at the obligations contained in the Climate Change Act, right? So I think that influences their approach. I'm not sure if I am answering your question, Luca.
I think that answers the question. Thank you very much. We do not have any further questions. So I would like to thank you at this point for your presentation and for your answers, and we will move on to the next speaker. Thank you very much.
Thank you.
So our next presenter is Kertu Birgit Anton, who is a climate activist from Estonia. She works as a junior legal expert at the Estonian Environmental Law Center, which is also another one of our partners in the project within which we are hosting today's event. And most importantly for today, she has been active in Fridays for Future Estonia since its beginning in 2019, and is a member of the core group of young people who won Estonia's first climate court case against the construction of a state-owned shale oil plant. This case is also the subject of her presentation today. And Kertu, thank you very much for joining us, and the floor is yours.
Thank you very much for this introduction and for inviting me here. I'll just try to get the slides on the screen. I hope you can see them now. Can you just let me know if you can?
Yeah, sorry, I was just pointing the finger. Everything is fine. Go ahead.
Perfect. So yes, as I said, I'm active both in Fridays for Future Estonia and also in this Estonian Environmental Law Center. So today I'll be talking about the first climate court case in Estonia and in the Baltics from both of these perspectives. But first of all, I'll just tell you a bit about what both of these organizations are. So Fridays for Future is part of the global movement with the same name that got started some 5 years ago. And the officially registered organization in Estonia has the name MTÜ Loodusvõlu. So it's a very Estonian name. But this is the official legal body that initiated the court case, but we did it as Fridays for Future as the movement in Estonia. And then Estonian Environmental Law Center is an expert organization that provides legal advice on environmental law matters, but also we engage in advocacy work for the protection of the environment. So I'll first tell you a bit about Estonia to give you some context for this court case, because I think parts of it are a bit specific to Estonia. So as you probably know, Estonia is this tiny little country, fairly far in the north. And although we are very tiny as a country and as a population, our contribution to climate change historically has been disproportionately high, as you can see on this graph. And most of our carbon emissions still to date come from the oil shale industry. So oil shale is a fossil fuel that is kind of like coal, except for that oil shale is far less efficient as a fuel. So to produce the same amount of electricity or energy from oil shale, you need to actually extract and burn much more of it than, for example, compared to coal. So the emissions are also higher. And most of our emissions come from this small region that is noted here on this map. And that is because the oil shale industry is located in that area. And this is also the focus of this climate court case. So it began in 2020 it happened to be during the COVID pandemic, when the government allocated some 125 million euros to the state-owned national energy company called Eesti Energia. And they engage in electricity production, and also they produce oil from oil shale. So oil shale is, in that sense, versatile, that it can be used both for producing electricity and also for producing oil. And this is an image of one of the existing plants from the construction site where this current plant is being constructed. So this plant produces oil that is, the far majority of it is exported, and it's exported even to outside the EU because it's so polluting that it doesn't comply with EU environmental regulation. And it's used either as ship fuel or sold as low-grade gas in so-called third world countries. If the plant is turned on and it begins operations, it will increase Estonia's national carbon emissions instantly by about 6%. And when the burning of the oil that happens abroad is also accounted for, its emissions actually double. So it is a major way of exporting our emissions. And this plant also creates some 61 jobs. So actually, it doesn't really that much help with alleviating the problem with lack of well-paying jobs in the region. So after the government made the decision to fund the plant, the local government, the local municipality of Narva-Jõesuu, issued it a construction permit very quickly. And then, first of all, youth organizations, scientists, and public figures all sent public letters to the government asking them to reverse the decision, but this didn't have any effect. So in the end, Fridays for Future, or officially MTÜ Loodusvõlu, decided to take the case to court. So we took so what we focus on is the construction permit that was issued to this plant, and not actually the funding decision, because we didn't have any kind of standing to contest that. So we're focusing on the construction permit. Our main argument in the case is that constructing the shale oil plant is incompatible with alleviating the climate crisis. But also, we address some of the efficiencies in the environmental impact assessment, so that this relates to the small particles emissions, the management of phenolic water, which is a byproduct of producing oil from oil shale, also the lack of assessment of the plant's climate resilience, and impacts on Natura 2000 areas. One of them is really close to the site, some others are a bit further away. But more about the climate argument, because this was really the foundation of the case. So the relevant acts that we refer to are the Paris Agreement, the UN Development Goals, and some strategic planning documents that were in effect back then and mostly still are today. So to date, Estonia still doesn't have a climate act. So there are no climate targets that are specified in the law itself. So that's why we had to refer to the strategic planning documents, which are more of the soft law instruments. And this in itself was somewhat problematic because the municipality argued that they don't need to consider this because they're not actual law. And the main shortcomings that we argued in the environmental impact assessment were that, first of all, there wasn't a specific environmental impact assessment carried out, but instead they referred to the strategic environmental assessment that was carried out earlier, and which they claim to have carried out with the precision of an environmental impact assessment. But we didn't agree with that. We found that too generic. Secondly, we argued that the assessment altogether excluded the emissions of burning the oil, so basically half of the emissions that are associated with the operations of this plant. And we found that very relevant because there isn't really anything else to do with this oil. So when the municipality issued the construction permit, they knew that it was going to be used to produce oil that is used to burn. So it can't be separated from the plant, we argued. And we argued that the climate impact that results from the operation of this plant is unacceptable because it doesn't, it makes it very difficult to comply with the targets in the Paris Agreement and in the other relevant acts that we referred to. The first small victory that we had was about a year after we submitted the complaint, and this was when the court temporarily suspended the construction of the plant because they found, we argued that the impacts on the nearby Natura 2000 area hadn't been properly assessed, and the court agreed with that. However, later on, the administrative court dismissed the complaint, and also they lifted the interim injunction because in the meantime, they had carried out a rapid assessment and found there to be no significant impacts. And then the circuit court also dismissed the complaint a year later, after which we took the case to the Supreme Court, who last year annulled the construction permit and stopped the construction of the plant. So the first climate court case in Estonia and in the Baltics resulted in a victory. However, when we look into what the court said, it was interesting that although the construction permit was annulled, it was not done on climate grounds. It was actually done because of the other deficiencies that we found in the environmental impact assessment. So the court ordered the municipality to assess these impacts as well, and then make a new decision on whether or not to issue the new construction permit. But still, the court elaborated in length on the climate impact of the plant and how it should be accounted for. So this has been very significant. So one of the important things the court said in this ruling was that the court stated that the climate impact of the plant that results from the operation of the plant must already be taken into account when issuing the construction permit. So the municipality and also Eesti Energia, the company, both argued that the climate impact that results from the operation is a matter for the integrated environmental permit that is issued later on. But the court stated that although, yes, finally the decision whether or not to allow the carbon emissions from the operation of the plant, that is decided with the integrated permit, a preliminary assessment already must be carried out beforehand, because the municipality shouldn't issue a construction permit to a plant that they already know that can't begin operation because of its large climate impact. Then the court also stressed that the climate targets included in strategic development documents are relevant and must be taken into account. So despite the fact that Estonia doesn't have a climate act, there are no hard law climate targets in Estonia, we still have some climate targets, and these must be taken into account. And regarding these climate targets, the court concluded that the assessment of the climate impact of the plant is limited by the scope of the national climate targets, because the court found that as there is no strict upper boundary of what is considered to be an environmental threat in the context of climate change, the court took the position that if the operation of the plant stops Estonia from meeting its national climate targets, then definitely this constitutes an environmental hazard or threat. But then the impact of the plant must be compared to the national climate targets. And as the national climate targets only are set for the Estonian national climate carbon emissions, then the broad emissions of this plant should not be taken into account. So this is why the burning of the oil and the emissions that result from this do not need to be assessed. I need to take a sip of water. Then the court also stressed that the risk of not obtaining an integrated permit lies solely with the developer. So if, for example, climate targets are made stricter during the construction process, and in the end they don't get an integrated permit, this is not a risk that the state or anyone else should carry. And they also went as far to say that there is no existential need to start the operation of the plant. And the court went even further and gave some general direction for Estonia's climate regulation. So they stated that Estonia has a constitutional obligation to make a proportional contribution to the achievement of the targets of the Paris Agreement. And this is very significant because it's the first time that the court in Estonia stated that really climate change must be taken seriously also in the legal sphere. And in the end, the court stated that without having a clear framework that sets out the final climate targets, interim targets, and so on, it can't be excluded that allowing such a climate-intensive, carbon-intensive installation infringes people's fundamental rights in other sectors in the future. But then, in the past half a year after the ruling, there have been some interesting developments with the case. So although we won the case itself, the municipality went on to issue a new construction permit after they assessed the environmental impacts that had been left out. They found there to be no significant impacts, and so the construction resumed. And now the plant is almost completed, but it is still unclear if it can begin operation. To enable it to begin operation, at least for a while, the government agreed to amend the law very rapidly last year to allow the plant to be issued an integrated permit with a deadline. So normally integrated permits are issued without a deadline indefinitely. But in this case, they decided to create an opportunity to also issue an integrated permit with a deadline, so that the plant could be given a permit to operate until 2035, which is the year when Estonia has its next national climate target. So the idea is that if the plant stops operation before 2035, it can't interfere with achieving that target, because that year it won't operate and it won't affect Estonia's carbon emissions. And so what's next regarding the plant and its future? The draft of the integrated permit was published on the 1st of April, and this includes issuing the permit until 2035, as I just explained. And the planned operation of the plant is planned to start operation later this year or earlier next year. But also, in the background of this, the climate act is being drafted with hopefully the first specific climate targets for Estonia as a whole, and also for sectors to be specified in it. But we're not yet sure how this is going to affect the operation of this plant. So this is an overview of the first climate court case in Estonia. Thank you, and I'm looking forward to your questions on this.
Thank you very much, Kertu. This was a good introduction of your case. I see some similarities with the way the government in Slovenia is operating. Basically, if the permit is not given, then they change the laws. So this is something that seems to be happening everywhere. So thank you again, and congratulations for the victory. And I see that you will have to continue to follow this case.
Unfortunately, we will.
Unfortunately, yes. Yeah. So firstly, I would like to ask you if this is still the first, let's say, successful climate case in Estonia. And then the follow-up question, what would be your #1 advice from the legal or other point of view to, let's say, other civil movements, Fridays for Future maybe in other countries, NGOs across EU in particular, how to prepare such a climate case? Let's say, I will not elaborate much further, but in Slovenia, for example, we're considering a national climate case.
Yes, this is still, to date, the first successful case that was mostly built on climate arguments. There have been some other cases now after this where climate change has been one of the arguments, kind of like a side argument, a supportive argument. And some of them have been successful. For example, recently there was a case related to peat extraction in a bog. And in the end, that was also successful. The extraction was not issued a permit. And one of the reasons was that wetlands are very important for sequestering carbon from the atmosphere, and the Environmental Board had not considered that part and the value that the peatland has for biodiversity. So, and there the Supreme Court also somewhat referenced the ruling in our case. Now, regarding the other part of your question, what advice I could give? I think something that I really learned through this case is that when we began it, we were 3 students, one other young person, and a very small law center as the ELC is. So we're just a handful of people, and it still turned out to be possible to win a case against a state-owned company that is, basically backed and funded by the state. And this is something that we couldn't really imagine, but we also couldn't imagine giving up and not trying out this avenue. So I would say maybe this is one of the important bits, that even if it seems really, really daunting and maybe also legally very innovative and not exactly sure of success, if possible, still try it out.
That's great.
And also, sorry for my voice, it just disappeared somewhere partly.
Don't worry at all. Take another sip of water, relax your voice. We have a question. Yeah, we have 2 questions now. So one is from our next presenter, Luca. Did the court look at any other national jurisdictions regarding the issue of Scope 3 emissions and the decisions of the courts there?
Not to my knowledge. And I think what is difficult here regarding climate change and in Estonian law, at least, is that we don't have national targets set in law. So before this ruling, it was unclear whether the targets in the strategic documents need to be taken into account. But for many other environmental nuisances, we have specified levels above which they're considered threats. But this is not the case for carbon emissions. So it is still unclear, how many tons of emissions resulting from a plant is to be considered an environmental threat and only accepted in exceptional cases. So this is, I think, what the court mostly dealt with. So where to find this threshold, and in the end, they found it in the national climate targets that are specified in the development documents.
All right, thank you. Okay, there's no hand up anymore. So there was Matjaž Vukal as well, who is basically asking if you consider the case a success. If the shale oil plant is operating, it should not be operating, right?
It should not be operating, in my opinion, and it is not yet operating. So the Environmental Board issued the draft of the integrated permit that would allow it to begin operation probably somewhere later this year or earlier next year. But as of now, the plant is almost completely finished, but it is not yet operating because they don't have the integrated permit. However, I still do think that the case was successful because we got this very significant ruling that has been very instrumental in the Climate Act advocacy, because there is this part where the court lays out, in their opinion, what the climate law or climate legislation in Estonia generally should look like. So this has been very useful in the Climate Act process. And also that it brought general clarity to how climate impact must be assessed in other projects, also in the case of this project. So now when we're following the integrated permit and giving feedback to that, then also we can refer to what the court laid out. I'm sorry, in that ruling. So yes, although even in case this plant in the end begins operation, I still think it's a success that we got this ruling, and also the fact that the construction was somewhat delayed in the earlier part of the lawsuit because of the interim injunction. This actually has delayed the completion of the plant by some months, and also after the Supreme Court ruling, when they had to begin conservation works because they were not sure if they were going to get a new construction permit, this has also delayed the completion of the plant, which means that in the end, if the plant even does begin operation, its lifetime, its total operation will be shorter. So that means that its total carbon emissions that result from it altogether will also be smaller. Well, it will still be significant, but in this time in the climate crisis, every ton matters, so we will still have done something.
Great. Just one more question from my side. How much effort or attention did you give to the PR aspect of this lawsuit?
We did give it quite a bit of attention because, as I mentioned, it's the first climate case in Estonia. And also it was quite interesting, and it got a lot of attention and interest from the media. I think partly because of this difference in the size of actors. So there's this tiny NGO of young people against basically, well, it looks like against the state, although legally we were in the court case was against the municipality. So this created this interesting narrative that the media did take interest in.
All right. Thank you very much,
Thank you very much.
This is it for the questions. Thank you for participating, and we will move forward now with our next presenter. As you saw, I did not take a break. I hope I hope we didn't need it in the end, but we will finish the event sooner because of also not taking the break, and thanks to the discipline of all the presenters. So, last but not least, I would like to present our last speaker for today, Lukáš Trubal, who is my colleague here at PITS, who joined our team in the beginning of 2024 and is already presenting. Lukáš studies and research work in environmental law at the faculties of law of the University of Oxford and Edinburgh, has given him the resources to engage in developing legal topics such as climate rights and litigation right now. Through his research, he's currently focusing on these different aspects of legal responsibility of corporations and climate change. This will also be the theme of his presentation today. So Luca, the floor is yours.
Mute. Hello, thank you, Alyosha, for setting the stage. I'm really happy that I can present some part of my work here. Let me just start the presentation here. Today I'm going to talk a bit more about the corporate responsibility and liability for climate change. As you've heard already before in the previous presentations, we were focusing more today on the responsibility of states and municipalities and public actors in general with regards to climate change. However, I'm going to focus more on the corporations and on the private sector, because this also represents an alternative avenue of responsibility for climate change that is more and more increasing currently. As you can see on the right-hand side of my slide, the corporate sector actually presents huge contributions to climate change with their large greenhouse gas emissions. As you can see in the graph on the right, those contributions are distributed in a very concentrated manner. This is taken from a very famous carbon majors database that was compiled by Richard Head and colleagues from the Climate Accountability Institute. And this is from an older iteration of this version. However, according to the fresh analysis from April this year, 70% of all CO2 emissions that were emitted from 1751 onwards can be attributed only to 78 corporate entities. So basically, from the beginning of Industrial Revolution onwards, only 78 corporate entities can be blamed for 70% of CO2 emissions. Another factor why corporations are also important in this regard is that they're responsive to market signals. This was a very famous conceptualization by the Stern Review, a very influential review from the UK, that climate change is the greatest and widest ranging market failure. In this sense, as corporations are market actors, they can be very important in remediating this market failure. And finally, they also present quite a substantial pot of money for undertaking climate mitigation and adaptation actions. Here on the slide, you can see a table that was compiled by Climate Analytics, and that presents the financial gain of carbon majors, of basically 12 most polluting entities in most of current history. From 1985 to 2018, 12 most polluting entities achieved $21 trillion of a financial gain, whilst they caused estimated damages of $15 trillion by causing greenhouse gas emissions. This is again taken from the same basically the same database of carbon majors. And also, I'm going to be discussing here responsibility and liability. I just want to stop briefly and just enunciate the differences between the two terms. Responsibility is something that one ought to do. It doesn't really tell us what is the basis of this, whereas liability is more of a legal thing, right? It's a consequence of legal norms. And in terms of legal liability, when we are discussing corporations and climate change, compared to nation states, there are less available legal remedies here. There is also less case law available. But here also has to be reiterated that litigation against corporation is increasing, it's diversifying, intensifying, and even in some cases succeeding. On the right, you can see a graph that represents the number of cases that have been lodged against corporations in the last years. And you can see that there is quite an increase, steady, but still quite an increase in the last years of lawsuits filed against corporations. A very interesting part of this is also that those cases are now concerning a more diverse set of actors. It's not only carbon majors anymore. It's also, for example, corporations from food manufacturing, from cement production, etc. What I want to give you with this presentation is an overview of the most crucial elements of corporate liability in climate-related cases, in order to understand where responsibility for climate action can turn into liability. I want to point to pertinent cases against corporations from the European context, and it's not my intention here to go too much into detail regarding specific cases, but rather to present groupings of climate rights concerning corporations. So if I start with the most general basis of liability, this is the general civil liability. It's comprised of different bases of liabilities, or what would in English law be called torts. And most commonly, which torts are used in the climate cases against corporations? It is either negligence, nuisance, or infringement of personal rights. Sometimes also trespass is used, but this is much rarely. A very important question here is also the jurisdiction of courts, which arise from the civil cases. But here the answer on whether there is a jurisdiction of a specific court really depends on the case at hand. It depends on the respondents or the defendants. It depends on the plaintiffs, as well as on the substance matter at hand. For instance, in the case of Royal Dutch Shell, which will be presented in the next slide, the plaintiffs have invoked the rule of jurisdiction where the damage occurs to establish the jurisdiction of the Dutch court over the activities of the wider Shell concern. An important consideration here is also what do the plaintiffs actually request. They can either request injunction or they can request damages. But most commonly in current cases, the injunctions are being requested. This means that they are requesting that, for example, the polluting entity is ceasing with the pollution or at least reducing it. But there are also some cases, as you will see later, where damages are being requested. The first and probably the most famous, the first successful, and probably the most famous case of responsibility, legal responsibility of corporations is Milieu Defensie and others versus Royal Dutch Shell. It's a lawsuit that was based on negligence, or as it was, or as it is known in the Dutch law, on duty of care. This is very similar basis of responsibility as it is in Slovenia, neposlovna odškodninska odgovornost. And here of particular importance was the question of unlawfulness of the emissions. Similar to the Urgenda 1 judgment, the court relied on the standard of unwritten rules of law. Interestingly, in this case, the main source was taken to be soft law for multinational corporations, the so-called UN guiding principles on business and human rights. And this was regardless of whether Shell adopted or endorsed them or not. The court went on to elaborate the duty of Royal Dutch Shell to exhibit due diligence to prevent human rights violations in the entirety of its corporate group that it governs and in its whole value chain. In practice, this is very important, as this means that Shell was found responsible to decrease the Scope 3 emissions, even from the consumption of its products by consumers or by other corporations, which actually in practice constitute the bulk of its emissions. Shell is a carbon major that produces fossil fuels, so you can imagine that including into its legal responsibility also the responsibility for the consumption of its products can be quite enormous. It was the court approved an injunction to decrease greenhouse gas emissions of Shell by 45% across all scopes until 2030 from the 2019 levels. However, here an important point is that the court distinguished the types of legal responsibility for decreasing emissions. Direct emissions must be decreased, what civil lawyers would usually call obligation of result, whereas indirect emissions of RDS must, for the indirect emissions of RDS, they must exhibit sufficient level of effort to decrease them. So obligation of endeavor. What also has to be noted here is that the case is still under appeal, and the decision will be published of the court in November this year. An important consideration is also that there are very similar cases arising in other jurisdictions. For instance, in Italy, where the Greenpeace Italy and others are suing another carbon major, ENI. In the case of Luciano Giulia, which is also a very important case, the plaintiffs requested quite a different thing. Basically, this is being litigated in front of the German court from 2015 onwards. And the plaintiffs are requesting here for a contribution to adaptation measures for climate damage in Peru from a German utility company. The requested damages here correspond to the evaluated damages. The requested damages here correspond to the evaluated amount of their historical emissions from RWE. So this is 0.47% of global emissions from the Industrial Revolution onwards can be attributed to RWE. And this is again coming back from the carbon majors database that I was mentioning earlier. A very interesting legal point here is that the plaintiffs are relying on neighborhood law, basically on the responsibility for emissions. And in the Court of Appeal, when it allowed the case to proceed to trial, they also noted that climate change are basically establishing this global neighborhood in which a Peruvian farmer can effectively sue a German utility company for the damages that are happening in Peru. Currently, the case is still on the point of evidencing. The court is seeking the evidence of the risk to plaintiff's property and the contribution of the defendant to this risk. And again, very similarly, as is the case with the Shell case, it's impacting other jurisdictions. And probably one of the most famous cases in this is the Asmania and others versus Holcim, where Indonesian residents are suing a multinational corporation for production of cement from Switzerland for the damage that is arising in Indonesia. And similarly, they're also requesting the contribution to the adaptation measures, as is the case with Luciano Giulia versus RWE. Besides the general liability in the civil law, we have also some legal bases that are arising that focus concretely on climate change. The first is definitely the disclosure, and that's really important in this regard, is the disclosure of climate-related risks. In 2019, first climate-related bankruptcy occurred when a utility company, Pacific Gas and Electric, was faced with liability for wildfires in California due to their faulty electrical lines. The damages then were estimated to be around $30 billion, and those damages were exacerbated by the heat waves that occurred in the years 2017 and 2018 and were caused by climate change. On the basis of such findings, the Task Force on Climate-Related Financial Disclosures was formed, which recognized physical and transitional risks that are related to climate change and their material effect on investors. In their recommendations, they provide guidelines on the company, on what the company has to disclose regarding their activities surrounding climate change. This is pertaining to their governance structure, to their strategy, how to navigate the risks and opportunities of climate change, how they manage the risks arising from climate change, and to disclose metrics and targets concerning climate. This has led to wide-scale adoption of climate-related reporting practices. And on this basis, the EU also recognized and adopted a Corporate Sustainability Reporting Directive, which was adopted in 2022, which basically establishes obligations on what needs to be reported in the management report regarding sustainability. This includes information necessary to understand the undertaking's impacts on sustainability matters, and information that's necessary to understand how sustainability matters affect the company. This is sometimes also called the double materiality of sustainability impacts. Concerning climate, this includes business model and strategy regarding reaching the 1.5 target, greenhouse gas reduction targets, policies, risks, governance, due diligence, etc. European Commission also adopted a very complex set of reporting standards that companies must adhere to. And a very important point here, as was also shown in the Royal Dutch Shell case, the directive also requires reporting, including value chains. And this is a pertinent point that has to be taken into account when reporting. A second point that has to be emphasized regarding the more climate-related obligations of companies is to identify, assess, mitigate, and report on the human rights risks associated with their operations and across their whole value chains. This is the so-called due diligence, as was already mentioned before in the Royal Dutch Shell case. It arises from soft law, the OECD guidelines on multinational corporations, and from the UN guiding principles, and can as well not only be a separate obligation, but can also be can comprise this very general civil law obligation. However, despite this possibility to include it into the civil law obligation, it is more and more coming forward as a statutory obligation. This has already happened in France in 2017, as well as in some other European states. But most importantly, the EU is just adopting a corporate due diligence directive, and actually it is just today voting on it in the plenary session, so watch out for that. And very interestingly, this EU proposal on corporate sustainability due diligence envisages a very wide framework that would affect approximately 17,000 corporations in the EU, as well as corporations of third country companies. There are some problems here how to enforce those obligations due to geographical and personal limitations of the jurisdiction in question. French law of vigilance, the one that was mentioned before, allows enforcement through civil litigation by private parties, but many questions regarding this is still arising in practice. The EU proposal enables civil litigation as well as provides quite substantial penalties for the companies that are not abiding it. Here I can mention that it is demanding from member states to impose penalties that are not less than 5% of annual net worldwide turnover. A more novel and a less discussed avenue of responsibility for companies is duties towards the shareholders and the company. This is based on corporate law, and it is illuminating pathways that are seeking to utilize rules on corporate governance to fulfill the corporate potential for climate change mitigation and adaptation. Corporate law is allocating rights and obligations of the constituent parts of the corporation. And most importantly, it underscores the responsibility of the company management to act in the best interest of the company. In order to ensure that this is so, law gives several remedies to different constituent parts of the corporations. Here I can mention management, shareholders that are acting on behalf of the company, or even minority shareholders through derivative lawsuits. This is particularly important in terms of investments in fossil fuel infrastructure. Now, there is an increasing concern that they may become stranded assets, which would become economically unviable. That would happen due to the price of production and the cheaper alternatives existing, for instance, renewable energy generation. For example, it was estimated to be cheaper to replace 99% of the existing coal power production capacity with renewable energy generation instead of continuing coal energy production in the US. Furthermore, increasing regulatory burdens on fossil fuels also make it prohibitively expensive. On the right of the slide, you see a picture of a very recent article that mentions here in Slovenia, very famous 6th coal power production unit in Šoštanj. As in the time of its construction, the unit was meant to be operational post 2050. In 2022, however, the government decided to stop producing energy from coal in 2033. This was due to the prohibitive costs related to its operation that is connected with the import of coal and with the payment of EU ETS allowances. Here, just to illustrate, the company that's in charge of the production of energy had to pay around 220 million euros for corresponding allowances just in 2022. However, in the last month, unofficial information has arisen that the government is planning to accelerate the closing of the operation of the power plant, which could take place already in 2026 or 2027, which is almost 30 years shorter operational time than expected at construction. Correspondingly, the stranded asset argument argues that fossil fuel infrastructure may prove to be a stranded asset and thus not in the best interest of the company. In line with this, there were already multiple cases that were picking up this line of argumentation in court and relying on corporate law provisions. In the Polish case of Client Earth versus Enea, the environmental NGO bought stocks from the energy production company, Enea, which wanted to build a new Block C of the Ostrołęka coal power plant. It initiated a legal proceeding against the resolution that would result in the investment in the new unit, as it would cause financial detriment to the shareholders. They argued that appropriate financing for the unit has not been arranged and that the investment presents a stranded asset. The court decided in favor of the lawsuit and annulled the resolution, not due to the financial argument, but because of formal mistakes in the enactment of the resolution. However, the investment did not proceed further as the Supreme Audit Office reported improper risk management by Enea. The company did proceed by suing the members of the management and supervisory board that voted for the investment in Ostrołęka C unit for damages related to their failure of due diligence. And this case is still ongoing and is yet to be seen what the final outcome of it will be. The final basis of liability of corporations that I'm going to mention today is in consumer protection. Here, most of you already know, this is concerning greenwashing. And this basically means that the company is communicating a better environmental, or in the case of climate change, climate performance, to consumers as it actually is. This prohibition arises from the prohibition of unfair commercial practices and the obligation of enterprises to communicate in a non-deceptive way. On the slide, you can see two examples of this. Below, you can see an advertisement from BP, from British Petrol, which is one of the carbon majors. And as you can see, it's heavily indicating that BP is going on a transition to renewable energy production. However, in the time of the case, it was found out that 96% of BP's annual spend was still on oil and gas. The second case is concerning FIFA World Cup in Qatar 2022, which was widely held as a net zero event. But this was found to be a textbook case of greenwashing, as the calculation that was used for figuring out that it's a net zero event did not cover all the relevant emissions. In terms of consumer protection, the legal basis is already quite well established. And here we have in Slovenian law, the most important is the Act on the Protection of the Consumer, which emanates from the wider European legal regime, and more specifically from the directive concerning unfair business to consumer commercial practices. Do not think that this does not already present a liability basis for the companies in terms of greenwashing, because it does. However, despite this, the EU decided to adopt a new directive that would deal with this even more explicitly. This is the directive regarding empowering consumers for the green transition, which bans unsubstantiated green claims as a misleading commercial practice, including when a trader claims that a product has a lower impact by resorting to carbon offsetting. Then in the follow-up to this adoption of this directive, the EU also plans to reinforce those responsibilities and liabilities of companies by the proposal for the Green Claims Directive, which will impose specific requirements for explicit environmental claims to substantiate them in business-to-consumer practices. Here, I've mentioned some of the cases. However, there is really a plethora of cases about this already across different jurisdictions in the EU. But maybe worth mentioning is the most recent one, which is Fossilfrei Netherlands versus KLM, in which basically KLM initiated an advertising campaign that conveyed to consumers that KLM is leading the transition of aviation to climate neutrality, despite the fact that its plans for air traffic growth was deemed to exacerbate the climate crisis. The NGO initiated court proceedings in order to declare misleadingness and unlawfulness of the campaign and to require KLM to retract its statement. The court found that the KLM's claims about the feasibility of KLM's targets that were supposedly aligned with the Paris Agreement painted too rosy of a picture concerning its support for alternative aviation fuels, as it was not concrete enough to be hailed a promising solution to decarbonize aviation. Relying on offsetting, as the court notes, also does nothing to reduce direct greenhouse gas emissions that are caused by flying. Thus, it cannot really be held that KLM is really alleviating negative environmental aspects of flying. To conclude, I would just like to reiterate some points. There are really strong indications of corporate responsibility regarding climate change transforming into liability for their actions. There are very important statutory developments that are currently ongoing, particularly in the EU, that are important for corporations as well as for the civil society. Here I can mention the Disclosure Directive as well as the Due Diligence Directive. Another point that has to be noted is that climate litigation risk is an important climate-related transition risk, as noted by the the Task Force on Climate-Related Financial Disclosures. It has already been shown by the reports that you can see on the right that there is a correlation between litigation and stock value. As an example here, I can present to you that basically they found the cumulative abnormal return of the RWE's share from the Luciano Lula versus RWE case over the event window of this case's filing was -6%, which meant that the return on the investment in this time was lower for 6% than it was predicted before the case happened. There are also important compliance considerations for the corporate sector here regarding climate rights. And with this, I will stop. Thank you for your attention and looking forward to any questions that you may have.
Thank you very much, Luca, for your presentation. There were a lot of interesting cases. Maybe we can discuss them a little later. But first, the first question would be from Professor Vasilka Sancin. What do you think about the fact that the corporate sustainability due diligence directive did not specifically include the Paris Agreement in the annexes list, among other specifically listed environmental treaties?
Yeah, this is a very interesting point because I mean the Paris Agreement does establish a very strong and robust, let's say, accountability framework. It's not really accountability from the standpoint of national legal orders, but accountability in a more wider sense. However, I would really reiterate here that the climate debate, and which I think is good, is now proceeding on the national levels. The Paris Agreement is important, and it is important for national states and for the EU, which is also a party to the agreement. But when we are discussing this for example, in the EU, I wouldn't say that this is the most important thing. It's more important that we realize that the Paris Agreement is just the starting point. Furthermore, this, on the other hand, this could be at least noted in the recitals of the directive. However, I wouldn't say that this is something that would really affect the implementation of the directive.
All right. The next question is from Georgia Bielica. And if I understood correctly, what is the role of investors? And is it too optimistic to think that investors or financial institution may strengthen climate action as well as human rights respect?
Yeah, thank you for your question. I think that they have some sort of a role to play in this, because it is a more and more recognized risk to deal with to basically adopt your business model towards the climate future that we are going to be living in the next decades and centuries. And basically here, I would really like to reiterate a very fascinating point that I found in the strand of lawsuits that are now being conducted in the US against carbon majors. As you probably all know, the carbon majors have predominantly already knew about climate change from 1950s onwards. And in their adaptation actions, they did account already for the rising sea levels by building the oil platforms on a basically higher level. And this really shows how important that is. And they are understanding this point. And I think that investors are increasingly doing as well. But it is here really a level of caution, because this is still, the states are there to lead this. And the states, as mentioned in the Stern review, this is a market failure, and the states have to remediate this market failure. And it's their first responsibility of them. But that does not mean that the investors, the companies, do not have their own role to play in this.
Thank you. And perhaps a question that I have for you, it is still very interesting for me. The shareholders can actually sue the management of companies, of corporations, and actually win in the climate-related issues by stating that the company will lose basically money in the long term with its investments. So this is something that is very interesting, and it's fun to follow this development. But is it, in your opinion, more fair or just to file suits against private corporations, companies, or state and public entities? Or maybe a sub-question, do you think that we should all become shareholders of fossil fuel companies?
Yeah, thank you for your question. This is a really interesting one. I do think that, again, responsibility in terms of a moral responsibility is definitely allocated to different actors, in the corporate sector as well as in the sector of states. When it comes to legal liability, I think still, yes, we should rely more on the liability of states. We are probably not there yet with the evolution of the legal frameworks to just basically go around and sue whichever company we feel like it's doing something wrong about the climate. And even it's not right to do so. However, I would really like to acknowledge here the findings of the Carbon Majors database, which is really striking to me. That basically from the start of the Industrial Revolution, there were only less than 100 corporate entities that did profit from those, from fossil fuels, and that basically have directly or maybe more indirectly caused the climate crisis. When it comes to the lawsuits that are arising from the corporate sector, there are very interesting developments in this. This has slowed a bit in the last, let's say, a year or 2 years. But before, there were really hard pressures from investors that were, for example, from hedge funds and, basically from funds that do deal with quite substantial pots of money to order those carbon majors into doing what is climate okay. And for example, there was a very famous development, I think it was concerning Exxon in the US, where let's say climate conscious hedge fund basically brought so much pressure onto the board of Exxon that they had to consider deposing the current management board and basically go more into the direction of climate-friendly activities. Again, here I really have to reiterate that it's not the case that I think that this will all now succeed and everything will be okay and that this is the only avenue to go. But it is an important avenue that companies as well as the civil societies have to take into account where they're approaching this topic.
So the Corporate Due Diligence Directive was just adopted in plenary. And there was quite some controversy about the Paris Agreement inclusion, which we already discussed, but also it seems that climate change impacts are excluded from corporate liability, states Elena Lunder. Companies under the scope of the directive are only obliged to put into place climate transition plans and not to check climate impacts in their due diligence. Do you see this differently? Might there be a way to expand this understanding? So perhaps we would still need to look at the final text and so forth, but do you have a comment on this? And maybe because this has to do with access to justice as well, if I can ask you this final question, how would it be easier for plaintiffs to basically suit the corporations? What do you think has to happen?
Could I just ask you to basically say the first question again?
So it seems that climate change impacts are excluded for corporate liability. Companies under the scope of the directive, of the due diligence directive, are only obliged to put into place climate transition plans and not to check climate impacts in their due diligence. Do you see this differently? Might there be a way to expand this understanding?
Very similarly as Alyosha already put, I would handle legislative text. However, already the first part is important. And here we really have to consider that basically the sense has always been concerning states. And even though, you know, when we are slowly progressing in this, let's say, widening of the responsibility pool, we have to do it slowly because we also do not want to have, basically, we do not want to have too much of a pushback by the companies that are the relevant actors here. Because it's also very difficult to imagine a future, you know, basically in a climate neutral world where we do not have at least some of the actors that are still now important and they might also be responsible for what is going on now. So here we really have to tread carefully. And perhaps also in this sense, when we are legislating these kinds of actions, take a measured approach and not demand too much. And in this regard, the impacts definitely are important. But I do not see that as the major, let's say, the major problem if this is not included. Concerning the access to justice, yeah, this is a very interesting point. And here I would like to emphasize that in the cases of corporations, it was mostly either individuals that were suing, or in some cases, for example, in the Milieu Defensi case, it was also a case, basically class action lawsuit, which is also quite an interesting point to approach this. But there are no very important aspects of plaintiffs that would be from environmental associations. And in this regard, there would be some aspects of improvement. And I think in the due diligence directive, this is being actually a bit improved because I think that if I remember correctly, the due diligence directive does allow the civil lawsuit to be brought forward by an environmental association. Because here really it should be reiterated from the court case from the European Court of Human Rights, even though it is concerning the responsibility of Switzerland and not of a corporation, they are very importantly emphasizing that the value that environmental associations have in dealing with climate change. Because the climate change is such an intergenerational problem and such a wide and polycentric problem that it is really difficult to say that one individual should save this. And the environmental associations do bring this into the perspective. There are also some more practical standpoints in which they could improve the access to justice. For instance, in Slovenia, we have basically the final edition of the Environmental Protection Act. We have liability of different actors, also corporate actors, for the violation of the right to a healthy environment. And in this case, the act is stipulating that the court expenses can be allocated, even if the case is unsuccessful, they can allocate it evenly to both parties, so that every party is responsible for their own emissions. And this would be the case when the court would assess that this is in the interest of environmental protection. And this is, for example, one way how the access to justice can be improved, because as you can know, those kinds of cases can be very expensive and also very lengthy, and loads of resources can go into this. And taking at least some measured approach to it is very welcome.
We did get one final question, and this is truly the final question. Rainer Lukitz is asking, is it still safe for companies to advertise that they are offsetting emissions? If yes, on what conditions? If no, doesn't it prevent companies from offsetting their emissions?
Yeah, thank you. That's a good question. Under the new directive, it will be very dangerous that they would claim that they are achieving net zero by resorting to carbon offsetting. However, it is just the point that they're offsetting their carbon footprint doesn't mean that this is problematic. They can carbon offset. They just shouldn't say that they are achieving net zero, but actually that they are doing so only because of carbon offsetting. The future of carbon offsetting is very bleak at the moment. As you know, basically after the last year controversy with Verra and its carbon credits, the amount of basically the pot of money that's in the voluntary carbon market has decreased significantly. And for now, it doesn't really seem that there would be much future in it. However, we shall see how that progresses. Probably on one point, this will become more tightly regulated. And here I can, for example, mention in the EU, we also will get, if the Council votes positively on it, carbon removal certification framework, which will actually regulate on a voluntary basis, but it will still regulate a part of those voluntary carbon market offsets. So there will be slow progression to this, and with the increasing legislation and the improvement of that legislation, hopefully also there will be a bit more reliance on, let's say, very verifiable and high quality offsets. And in that case, there might also come to some change of practice regarding the offsetting and their advertisement of their net zero targets.
All right. Thank you very much, Luca, for your contribution as well. And with this last presentation, we have reached the end of today's event. For whom the bell tolls, climate rights and litigation. Firstly, I would like to thank all the speakers for interesting and substantially packed presentations covering a very wide range of topics related to climate change, climate rights, and climate litigation options and existing cases. Secondly, I would like to thank all the attendees for joining us, for your attention, for your quality questions. And lastly, I would like to join also our partners in the Justice and Environment Network, with whom we are cooperating and pushing and researching these interesting developing legal fields and organizing events across several EU member states. And this is one of those events. The recording of the event will be published and freely available on the webpage pic.si, and also forwarded to everyone who registered for the event. So you will be receiving the recording of the event. Thank you all for your time, and I wish to all of us that at some point in our lifetime or the lifetimes of the next generations, The bells will be tolling only for celebrations, and we won't need to toll and warn us of new natural disasters anymore, at least not those caused by us. All the best to you. I hope you enjoyed the event, and goodbye.